what are the exact, because now entirety is before your lordships. So it's a short order apparently, but it seems to me that there are fundamental 7 points are there in the order. Now, Lordship, may kindly have a look at the 7 points, and then I will say why I'm saying it.
What are the order is before your, my lady.
Yeah, there is a reason I'm saying.
Please take your seat.
Yes.
Do you have a chair?
My lady, I'm feeling a chair.
No, please don't. Don't sit on somebody's lap.
No, my lady.
Better?
There'll be other problems.
DAG, please sit down.
Yes.
Please sit down. Please make chairs available for the senior counsels.
I think we should, among ourselves, take a vow, because it will have an impact hugely, so that we can inaugurate a congenial atmosphere one after another, so that we can make submissions. Because
You think the atmosphere is not
my lordship is controlling it, but there are lots of
Very congenial.
those are
yes.
all outwards, nothing inwards.
Now, may I just say, why did I say before Mr. Bhattacharya begins with the merit of the matter? There are 7 points. Lordship, kindly take these 7 points. Point number 1 is not important. Lordship's Moshumi's order were taken note of. Point number 2, liberty granted to approach the High Court by there are several petitioners before the Honorable Supreme Court. When I say several, there are 2 sides. One side, untainted, they got affected because they said the vacancy which was there in 2016 in some subjects, that was reduced. So that's in affectations. So even if I pass, because of that reductions, I would not be able to. And there are also, my lord, Mr. Bhattacharya's clients saying paragraph 31, therefore there is an illegality, expiry of panel, they should also go. There the Honorable Supreme Court third, no tainted candidate to slip through in the fresh selections on any pretext. So therefore, if anyone is tainted,
Let the court decide who is tainted and
that's I was about to say before your lordship enters
yes,
into
yes,
25.
yes. Also, possibly this was the issue
Yes,
you
this-
submitted.
Yes,
Or you are not.
but
tainted
this
or
has to
some-
be
I
hard
have
fast.
this in mind.
Milord,
Let him
these are
start.
all, Milord, all.
Let him start, please.
Yes, Milord, kindly come to, let us, Milord, we are concerned with the compliance of Supreme Court judgment. I shall place that also, but kindly come to, Milord, the notification. Page 53. This is the, Milord, advertisement seeking application for new selection, press selection.
Yes.
Now, Milord, in terms of every word is very important. 30th of May 2025. In terms of the judgment and order of the Honorable Supreme Court. Therefore, this is not an independent selection process by the School Service Commission. Order of the Supreme Court in Civil Appeal number so-and-so, read it in MA. I shall also place the order passed in MA. The West Bengal School Service Commission has been directed to initiate fresh selection process to the post of assistant teacher for 9-10 secondary so-and-so. The Commission and the government of West Bengal have already applied for review of the said judgment, and order and its exercise is strictly subject to the outcome of the review. Review are dismissed. The notification is being issued for conducting second SLST for selection to the post of assistant teachers of class 9-10 in secondary, higher secondary, and to the post of assistant teacher in 11-12. So-and-so schools in West Bengal against the, underline this one, is very important, against the vacancies to be filled, directed to be filled up by initiating fresh selection process. And further vacancies, not this is really intrusion to the Honorable Supreme Court judgment. Further vacancies as may be received from the West Bengal Board of Secondary Education under West Bengal School Service Commission Selection Appointment Rules 2025. When the Supreme Court delivered the judgment, there was no existence of 2025 rules. Therefore, if you say that you are conducting the selection in view of the Supreme Court order, you are really diverting and violating the Supreme Court direction. That's why the Supreme Court last order said that whatever order you have passed, that is to be considered, not any subsequent observations or opinion. The entire process is being carried out strictly without prejudice to rights and contentions of the state, Commission and the board in their pending review petitions. Honorable Supreme Court Engineer so the commission, I am not troubling my life with that. Then the selection process will be governed by the School Service Commission Act 1997 and subsequent amendments to Rules 2025 and the relevant NCT and state government guidelines. Then my lord will turn over. I am not troubling my lord with this. Kindly come to clause 2. Eligible candidates with minimum qualification laid down in 2025 may apply online through the official websites and so. Therefore, you are now undertaking process under the rules 2025 with the eligibility clause. This is even the initiation. And therefore, you prescribe the eligibility clause. This is important. Then, kindly will not turn to next page, clause 7. Manner of selection. Selection to the post of teachers for 9, 10, 11, 12 in school shall be made. Will not kindly underline this. On the basis of written examination, evaluation of qualifications of the candidates, oral interview, and lecture demonstration to be determined by the commission. Therefore, that area of selection is specified. I repeat, written examination, evaluation of qualifications of candidates, oral interview, and lecture demonstration. There is no scope for any other element to be incorporated, which they sought to incorporate the so-called teaching experience. If advertisement does not make any room for that. Then preparation of panel. After evaluation of the OMR sheet, answer sheet of the written examination, the Central Commission shall prepare and publish in their website details of all candidates to be called for interview, strictly in accordance with preliminary merit score, category-wise on the basis of the rules 2025. So these are the important areas I will not point out to your lordship to show that you are inviting applications through an advertisement, giving the detail how to contest and what should be the methodology. Then kindly turn to page 56. Age limit shall be considered on the basis of age as of 1st January 2025. The age relaxation will be given to the candidates who have been given the benefit of age relaxation as per order dated 3rd April 25 of the Honorable Supreme Court. Provided further that a person who comes under more than one category shall be eligible for only one benefit of relaxation, which shall be considered most beneficial to him. Then next page note. Qualifications obtained on or before the last date of receiving online application mentioned in the application form shall only be counted for academic and professional qualification. Then the tentative schedule. Now, this is the advertisement. And this advertisement will not seems to be in accordance with the constitutional principle of Article 14 and 16. You invite all. Now kindly turn to rule 39. At page 39. Now, this is not without prejudicing my fundamental point that you have started this selection process in terms of the Supreme Court order, you say, and Supreme Court order which was passed, there was no 2025 rules. Though it's not recorded, latest observation of the judges are very clear. And that's why I say that only the final order should be considered, not the subsequent any opinion or orders. Here, Lord, should kindly come to this 29th of May 2025 is the publication of rules, and the publication of advertisement was on the 30th May. Well, just please notice. Kindly turn to page 40, the interview list. Interview list in respect of SLST means in case of vacancies in the post. In respect of means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration category wise on the basis of the preliminary merit score. That is score from written test and TET and academic score in the ratio of 1.6:1. Now this has been reflected in the advertisement. Then merit list in respect of SLST means in case of post, a list of candidates prepared category wise on the basis of merit, which shall mean in addition to what has been stated in Rule T121K, marks obtained in oral interview, lecture demonstration, prior teaching experience. This is the incorporation by which our allegation, we are freshers, by which you wanted to give credit to the appointments which were set at naught, declaring void by the Constitutional Court. This is without malice in law. You had never declared in the advertisement that there will be scope of any prior teaching experience. Now you incorporate this. Now kindly come to again, my lord, the rules in the schedule. Now, my lord, kindly, my lord, before that, lordship may turn to my lord, page 42. Rule 7, information regarding vacancies. The Commissioner of School Education shall, on being intimated by the West Bengal Board of Secondary Education, as and when deemed appropriate by the board, prepare a vacancy statement of assistant teachers, and with the approval of the state government, send same to the board. The board shall, with prior approval of state government, send a category-wise vacancy report. Now, the first question, if the rule is promulgated on 29th of May, advertisement is made on 30th of May, when did the board undertook this exercise to identify the vacancies? But it is humanly impossible that you could identify the so-called extra vacancies.
Yes.
Then the report, as mentioned above, shall be sent to the Central Commission in the following manner. Firstly, before the date of publication of the advertisement inviting application, there shall be termed as indicative vacancy. And finally, before the date of publication of the interview list, there shall be termed as final vacancy, which may increase or decrease in comparison to the indicative vacancy. The indicative vacancy, my lord, is the vacancy which would be arrived at after exercise of Rule 7, and that will be intimated. Lord, Lordship will definitely ask for production of the records to show. When did the exercise under Rule 7 was undertaken by the board to intimate the vacancies, which prompted the authorities to advertise very next day, 30th. Now, these are all stage managed, therefore I say. Now, kindly come to me, Lord, the rules schedule. At page 49. Selection to the post of assistant teacher 9 so and so. Now, I just take a lot of the relevant portions. Written examination, OMR based 60 marks, but which is in variance with the 2016 rules. I shall place that also. Educational qualification 10 marks. Here also, my lord, will be pleased to note, I will demonstrate that the assessment nature has been varied from 2016 rules. Based on marks of graduation, post-graduation, the subject for which applied up to this, my lord, level playing field. Then, prior teaching experience 10 marks. At the secondary level in a government or government aided or a government sponsored school, calculated on the basis of 2 marks for each year of service in substantive post as permanent or on contractual basis. Oral interview 10 marks, lecture demonstration 10 marks. Apart from this prior teaching experience, all other things, Lord, I would say, of the level playing field. All have the same benefit. This prior teaching experience is a new incorporation to ensure that these candidates, I do not give any adjective, whose appointments were cancelled, declaring void. Not some irregularities, therefore I cancel it, it is void. They have to be given the benefit, that is the reflection here. Now, my lord will kindly take to 2016 rules. Because they say that this is because of the Supreme Court judgment. Now, 2016 rules is 346. So kindly will not count to page 348. The qualification, that it really in fact starts from 347. Name of post, qualification and age.
Yes.
The appointment of persons to the post mentioned in column 2 of schedule 1 shall be made by selection, that is direct recruitment. This has also some bearing of service jurisprudence. They meant to say this is not a promotional post. Direct recruitment, therefore everybody will enter through the same channel, having same competitive qualification. Name of post so and so, that provided that the qualification of teacher includes academic qualification and professional qualification of teachers for 9-10 as notified by NCTE from time to time applicable on the date of advertisement. Provided further that the certificates obtained on or before the last date of receipt application as mentioned, application shall be counted for academic and professional qualification. Well, I am not troubling with the age limit. 347. So for the proviso is there for the teaching and non-teaching staff, then kindly come to that additional essential qualification of candidate. A candidate willing to be selected as teacher for class 9 and 10 of any school having Bengali or English and so, well, they have to have the language preference. A manner of selection. Selection to the post of teacher of 9-10 shall be made on the basis of the results of the state level test, comprising written examination conducted by the Central Commission, evaluation of academic and professional qualification, and personality test of the candidate in the manner specified. Now, there was no scope for any professional qualification. And also kindly come to the schedule of these rules. At page 352. Select the part A, the others are not disputed. Selection to the post of teachers for 9-10 in school shall be made on the basis of written examination, evaluation of qualifications of the candidates, and personality test to be determined by the commission in the following manner. Written examination, academic qualification, personality test. No professional experience. Sorry, the prior teaching experience. Then the part B, but similar. I'm not just troubling my lord with these similar things. Well, different qualification, 9-10, like that. And part B is also important. Here, my lord, how the best persons would be chosen for teachers category, there is a rationale, part B. Provision relating to evaluation of academic qualifications. It starts from school final Madhyamik. Full marks 10. If you have 60% above, how the marks would be distributed. For the higher secondary stage, then my lord, graduate stage, postgraduate stage. Therefore, your entire career is being assessed for selecting the best out of the lot. With 25 rules, my lord, this has gone. Just my lord, turn to page 49, my lord, you'll find here, my lord, this assessment of continuous academic career gone. Page 49. Yes. Schedule 2, I had placed written examination 55, it was modified anyway, but then how the educational excellence should be assessed based on marks of graduation or post-graduation, or not and. The other career, whether you had just passed through Madhyamik, somehow higher secondary, which you had taken note of assessment, now is removed. Only graduation and post-graduation. The intention of making these rules is to again give a leeway to those persons whose appointments are cancelled. Why? Now these are the rules. 25. Now I will trouble your shift to come to the Supreme Court judgment. Because the Honorable Supreme Court says you have to strictly go by the judgment which you had delivered. That judgment starts at page 60. Go there. 60. But excuse me, Miller, I would take the trouble to read the judgment in its entirety, if your lordship permits me. The impugned judgment, that is the High Court judgment, Division Bench judgment, at page 60, dated 22nd April 24, en bloc, set aside the 2016 selection process conducted by the School Service Commission, so and so. The appellants before us are the selectees, some of whom have been working over 5 years. They fall into two categories: selectees with purported evidence and material including wrongdoing, other selectees who claim that they were validly selected and have committed no wrongdoing. State also challenged. Now kindly come to the relevant portion. Para 20, illegalities in the selection process. At page 77. In our opinion, this is a case wherein the entire selection process has been vitiated and tainted beyond resolution. Entire. Manipulations and frauds on a large scale, coupled with attempted cover-up, have dented the selection process beyond repair and partial redemption. The credibility and legitimacy of the selections are denuded. High Court has referred the illegalities. I am not troubling my lad, but the Supreme Court's opinion is at the very beginning of this 8th paragraph. Then kindly will come to the directions. Kindly turn to page 90, the conclusions. The last question relates to the relief. Whether it requires any modification, we find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates were appointed must be terminated and they should be required to refund any salary payment received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. Till date, my lord, the tainted list has not come out. The tainted categories have been defined by the High Court, upheld by the Supreme Court. That I shall place later. For candidates not specifically found to be tainted, their entire selection process has been rightly declared null and void due to the egregious violations of the illegalities which violates Article 1416. Null and void. No person of that category can claim that I have an experience. As such, the appointments of these candidates are cancelled. However, candidates who are already employed need not be asked to refund or restitute any payments to them. Their services will be terminated. No candidates can be appointed once the entire examination process results have been declared void. No candidates can be appointed. This is the Supreme Court's clear verdict. Then, next, some of the candidates, appointed candidates, who do not fall within the category of tainted candidates may have previously worked. May I give a little background of this? Some appear says that we were properly appointed, we were working in different institutions, maybe primary teacher. But we thought we'll have a better opportunity. Since this recruitment goes, kindly restore that old recruitment where we are not tainted. And that appointment is never questioned. The Honorable Supreme Court, my lord, out of his grace, gives this direction. I mean, read it. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or with autonomous bodies. In such cases, although their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies to continue in service with those entities. Nothing to do with this teacher's profession here. These applications must be processed by the respective departments within 3 months, and the candidates will be allowed to resume their position. Further, the period between the termination of their previous appointment, their joining will not be considered a break in service. Their seniority, other entitlements will be preserved and they will be eligible for increment, so and so. Therefore, this is completely a separate category. Few who had earlier had a regular appointment. This will, because very well go back. Then lastly, we address the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment had held the appointee, Ms. Soma Das, shall be allowed to continue on humanitarian grounds. While we will not interfere with this finding, Soma is made an exception. We make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. However, in consideration of the disability, these candidates will be permitted to continue and receive wages until the fresh selection process and appointments are completed. Again, a special category. Very well, you continue till fresh. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required, with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate. Therefore, my lord, the disabled who are not specifically tainted, they will be allowed to participate. This logic on the last occasion, the Supreme Court accepted. Supreme Court said, read it similarly. Not that tainted disabled should be allowed to participate. Our observational findings will not influence the criminal proceedings. Accordingly, we afford the impugned judgment cancelling en bloc entire selection process, but have made certain modifications in directions issued by the High Court. The appeals are disposed of. Now, after this, government Miller takes out a miscellaneous application. No, application the kothay? Well, I'm just placed the application also. I have to cross title it. I just play, yes. Anyway, I'm not. Let us come to the order on their application, page 107. We are, got it. We are inclined to accept the prayer in the present application insofar as it relates to assistant teachers for class 9, 10 and class 11, 12, not found to be tainted, subject to the following conditions. An advertisement for fresh recruitment to the aforesaid posts shall be published before 31st of May 25. This is on the application of the state, the board. They made an application, though the copy of the application will place your lordship, that the schools running would be difficult. Please allow some of the teachers to continue to see that the education is not affected. Honorable Supreme Court said very well, only for the so-called untainted candidates till 31st December. In the meantime, start a recruitment process of the aforesaid post. And that application of board is at page 249. Yes, this is also important to place. At page 251, the instant application is being filed by the applicant seeking issuance of appropriate direction from this court pursuant to the final judgment and order dated 3rd April 2025. Therefore, they accepted that the judgment has reached its finality. If the appellant is an independent statutory body, so and so, I am not telling that. Then paragraph 3, the appellant had challenged the final judgment and order dated 22nd April passed by the Calcutta High Court, and that was dismissed. Then they go to the directions of the Honorable Supreme Court. Then kindly come to paragraph 6. By way of the instant application, got it?
Yes.
By way of the instant application, the appellant most humbly craves to seek appropriate directions or modifications of the judgment to permit the appointed candidates not found to be tainted, their own admission, to temporarily continue in various schools without claiming any equity in their favor until the end of academic year or until the process for fresh appointment is concluded. Therefore, fresh appointment will not is pursuant to the direction passed by the Supreme Court 30th April. Supreme Court fill up these posts. Therefore, they admit this. And on such application, their prayer was that the prayer was at page 260. Their MA application. The permit the appointees not found to be tainted to continue in service till the end of the academic year until the process of fresh appointments to such post is concluded, whichever is earlier. On that, the Honorable Supreme Court passed this order at page 107. It's very important. ছটফট করো কেন? An advertisement for fresh recruitment shall be published before 31st May because they say that we want to carry on the fresh recruitment process. The examination and the entire recruitment process shall be completed by 31st December 2025. Now, kindly will not take note of the direction of the Supreme Court that advertisement should be published by 31st of May for the posts which were found to be illegally appointed by the Supreme Court. On 31st of May, my lord, they issue 30th May, they issued the advertisement. 29th May, they issue notification for fresh rules. I would again say, my lord, the entire chain of action reflects, my lord, the malice in law. Then the state governments, this is very important. Supreme Court was so skeptic about their behavior. The state government, the applicant, that is board, and the School Service Commission shall file, nobody could not subsequently escape saying that I did not do it, shall file their respective affidavits by 31st of May, enclosing therewith a copy of the advertisement for the fresh recruitment as well as the schedule therefore, so as to ensure completion of the recruitment process by 31st December. In case the advertisement is not published, the affidavits are not filed, the appropriate orders will be passed by this court, including imposition of post and vacating of the order. In fear of this, it was done on 30th. Then this is important. We clarify that these orders shall not be read as conferring any special right or advantage on the apostate teachers in so far as the fresh recruitment process is concerned. Therefore, without this continuation, even for a limited period, they cannot take any advantage thereof because the entire thing was void. Supreme Court was very much not conscious of this prayer. Then we are not inclined to accept the prayer in the present application insofar as non-teaching post group C are concerned, as the number of appointees specifically found to be tainted in this age group is substantively high. And secondly, what was prompted to us to pass this order in respect of assistant teachers not found to be tainted is that the students undergoing study presently should not suffer on account of the lack of teachers. Now, your lordship has been pleased now to take note of this judgment, and Supreme Court says any observation you have made after our final order should not be taken note of. Here, my lord, the final order says everything is void, and then on their place says you allow them to continue for those posts without conferring any benefit to them. In this background, 25 rules I have placed, my lord, that the purpose was to, my lord, confer them the extra benefit, which is in total disregard to the Supreme Court judgment. And that's why the Supreme Court very categorically, if I may again take back to your lordship, says, since my lord's various orders were noted, these were flagged. The third page, the High Court shall examine the matters in uninfluenced by any of the observations on merits made by this court in the orders passed after the decision in Boishati Bhattacharya Supra. Therefore, the decision is conclusive. You cannot go beyond that. Now, my lord, these rules, according to my submission, my lord, is ultra vires to Article 14 and 16.
You are appearing for the freshers.
I am appealing for the freshers. And Lord, the advertisement invited. We are invited that this is the process of selection would be done. Now we find in the rules you have made such a provision which makes us almost impossible to contest. No level playing field. In that background, this virus of the rule is challenged. And if your lordship is with us, then, my lord, one chapter is closed. They have to do afresh. And if your lordship do not agree that this rule is not ultra vires, then my submission is that even the application of rules is made in such a manner to give illegal benefit in violation of that rules. These are the 2 points. Now, my lord, so far the virus of the rules is concerned, my lord, may I just take your lordship, my lord? to the authorities. রাখো আমি এক এক করে দেখাই ছটফট না করে। Let I take your Lordship Miller's statement to the latest judgment of the Supreme Court in Assam versus Rava, 2025, volume 7, SLST 705. The judgment is delivered by Justice Dipankar Dutt. এখানে আরে এটা তো অন্যটা 25/7 SCC দেখো আছে। জশবে দিয়ে দাও
এই তিনটে 18 নম্বর সিরিয়াল নাম্বার
আমার বই দাও। না আমার বইটা কোথায়?
সিরিয়াল নাম্বার
What are all these? These are judgments.
জাজমেন্ট কম্পাইলেশন সিরিয়াল নাম্বার 18
Serial number 8.
18
18. পরে হবে নিশ্চয়ই।
529 to 550 reported
529 to 552.
জাজমেন্টে এই একটা কম্পাইলেশন দিয়ে দাও নরেন্দ্রকে।
Give the first pages only, the references. You are not required to give the
Miller, this is
copy of judgments.
State of Assam versus Aravind Rava, 2025 7 Supreme Court cases, page 705.
ইন্ডেক্সটা দিলে তো
হুম?
জি কথা ইন্ডেক্সটা দিয়ে দিলেও আমরা ফলো করতে পারবো ইন্ডেক্সটা
হ্যাঁ দিয়ে দাও।
ইন্ডেক্সটা দিয়ে দিচ্ছি
Now, Miller, the relevant paragraphs would be, kindly Miller turn to paragraph 39. That the issue was whether in absence of statutory rules, by administrative order, appointments could be done. The Supreme Court was considering, yes. দর্শককে পেজটা বলে দাও না তো
39.
paragraph 39.
Yes, paragraph 39.
It cannot be gainsaid that the factors of when, which, what, who, and how that are associated with the recruitment or selection process is the prerogative of the recruiting authority and the selectors. However, at the same time, the process has to be conducted consistent with the statutory provisions governing the same, if any, as well as principles of absolute fairness and complete non-arbitrariness. Though it is true that law does not postulate a fetter on the authority of the employer, state, and it's within the domain of the government when to initiate a process of recruitment for public employment, either according to recruitment rules or even in absence thereof, it is for the government of the day to decide in which manner it proposes to conduct selection. What would be the various stages the candidate aspiring for appointment have to pass through in order to be placed in the select list? Who would be selectors and how weightage is to be given to each of the testing methods? A great deal of credence is lent to a process if it is fairly and transparently conducted in accordance with rules. Whatever be its source, without the slightest hint of any bias or favoritism or nepotism. Normally, it is not for the courts to interfere unless the process smacks of malafidis, that I have already tried to develop this point. However, the right to be considered for public employment being a fundamental right, it would be safe and prudent to have a recruitment rules to govern the process of selection so that the best possible talent is appointed in public service. Obviously, assessing the merit of the candidate aspiring for public employment on the basis of a prescribed standard would not only provide a level playing field for each of them, The excellence of an institution to which the appointment is made would depend directly on the proficiency of its number staff, and that would in turn depend on the quality and merit of those who offer themselves for selections and ultimately get selected, necessitating the selection to be conducted within a hidden taint or masked malafidis. Last but not the least, having regard to present times when corruption has been held to be a walk of life by certain responsible citizens of the country, it would have been desirable if the process of recruitment of 104 constables were conducted after framing recruitment rules and also prescribing a written examination to keep the process absolutely above board. What is the principle is there must be a level playing field. And you have destroyed the level playing field with a malafide intention. I have said, Lord, the malafide intention is not at all personal malafide, but malice in law is also malafide. This is the latest judgment, and another judgment will not to show whether any preference can be given at the time of initial recruitment, 1995 supplementary to SSC.
Entry 70.
না না আমি আমার বই থেকে বলবো
Supplementary to SSC.
page 235.
Entry 70. Supplementary to
Page
ইন্ডেক্সটা দিয়ে দাও না তো কথা
এটা কই বই
কাকে কাকে
1995 supplement.
রাহুল
টু দা
রাহুলকে পাঠিয়েছো রাহুল পাঠিয়ে দিই এই শিক্ষণ দিয়ে
এই জর্জকে রেফারেন্স তো দাও
We'll all learn more law.
আগে জজ সাহেবকে দাও ওদের পরে দেবে
Gives us an opportunity to learn the subject.
Now, this is a three judges bench order 1995 supplementary to SCC.
Got it. Thank you, my.
Has got it.
Yes.
Kindly turn to me, Lord, paragraph stated paragraph 13. Let me start from paragraph 11. We shall now briefly refer to the main grievances voiced by the learned counsel for the respective parties in connection with these two GOs. It was submitted by learned counsel appearing for non-Telugu speaking candidates that when a direct recruitment is appointed to any public service, maybe in the lower echelon of service, like Group T and Group 4 posts, which may consist of clerical posts, merit should be the criteria which the Public Service Commission should follow. If a candidate satisfied the basic requirement of eligibility for competing in such public recruitment, provision of such weightage of 5% of marks to Telugu medium candidates will only per se be arbitrary and discriminatory, and would be destructive of the concept of selection on pure merits. That even if Telugu be the official language as adopted by the state in the light of linguistic policy, once a candidate is recruited from the open market as per the relevant rules, before he is confirmed in service and before he is entitled to earn an increment in service, he is required to pass the Telugu language examination. This completely meets the requirement of the department that the candidate must be having working knowledge of Telugu to enable him to converse and correspond in Telugu with members of the public as well as the other government departments. This satisfies the object of securing efficiency administration. To put a further fetter at the entry point, now this is vital, by giving a special weightage of 5% marks on the aggregate to candidates who have passed their graduation examination Telugu medium would therefore have no real nexus to the object sought to be achieved and would be counterproductive, as more meritorious students, even though having secured more marks in the aggregate in the competitive test, would be elbowed out by those standing far behind in the queue only on the specious plea that they have passed the qualifying examination Telugu medium. But here the fact is so glaring. The fresh candidates even secured 100% marks on merit were out of competition because of 10 marks. That even these candidates who have passed qualifying graduate examination in English medium or any other medium in the state have to appear compulsorily in one of the paper of Telugu language. Therefore, he is also having sufficient working knowledge of Telugu to enable him to correspond in Telugu as required by the exigency of service. That when under the relevant recruitment rules for the post concerned, the minimum educational qualification prescribed is passing of graduation in any subject. The further question whether he has passed this examination in Telugu medium or English medium would be totally irrelevant. That if a candidate who has passed graduation examination in English medium cannot be told of the gets and can legally compete in the examination for recruitment to the public post advertised by the Public Service Commission, such imposition of 5% weightage of total marks in favor of candidates who had passed qualifying examination of graduation in Telugu medium would amount to imposing an additional qualification or eligibility criteria which is dehors the recruitment rules and would result in total arbitrariness and would amount to give a discriminatory and hostile treatment to all candidates who otherwise are qualified to contest but did not have Telugu medium at their graduation level. Well, if I may put my facts here, the language would be that the persons who are otherwise qualified to contest but did not have teaching experience will be out of consideration. It was also submitted that the object about maintaining the efficiency of the administration can also be achieved by providing or prescribing for one more paper in the competitive test on Telugu language itself, as in that eventuality all the candidates competing for examination will have an equal chance to compete for the said examination and show their proficiency in the subjects concerned in which they are examined. For all these reasons, it was submitted that the decision of the tribunal is quite correct, and similarly, the decision rendered by the single judge of the High Court, as he then was, is equally correct, and the division bench judgment which upturned it deserved to be set aside. Now, the relevant paragraph 13, I have given the factual background of that. We have given our anxious consideration to these rival contentions and have reached the conclusion that the impugned government orders and the consequential statutory rules framed under Article 309 proviso do not stand the test of Article 14 and 16 of the Constitution and will have to be declared invalid. The reasons for our aforesaid conclusions may now be catalogued as under. 1. It has to be kept in view that recruitment to public service through the Public Service Commission is the open recruitment where any eligible candidate is permitted to compete on a par with other competitors. The minimum eligibility criteria for recruitment to such post is graduation. Therefore, it does not mean that candidates who have passed their graduation in non-Telugu medium cannot compete for the said post. It has to be noted that the minimum educational qualification for appearing at the selection is graduation simpliciter. But kindly just go back to the advertisement, minimum eligibility criteria. If the object or underlying the impugned provision of weightage of marks on the aggregate to candidates who have passed their graduation in Telugu is to permit candidates knowing Telugu language to occupy the post concerned, then it cannot be said that merely because a person has passed his graduation in Telugu medium, he alone will be proficient in Telugu and not the candidate who has passed his graduation in any other language. For appointing persons to post in public services to direct recruitment, the criteria has to be pure merit. Therefore, all candidates who possess minimum educational qualification have to be assessed on the basis of their relative merits. At that stage of assessment, if 5% more marks in the aggregate are added in the assessment of candidates who have passed minimum educational qualification through Telugu medium, the very criteria of relative merits would get frustrated and would become assured. In this connection, we may usefully refer the decision of this court in case of Pradeep Jain versus of India, but I am not really reading the quotation from the other judgment. Then we'll kindly skip over, come to this paragraph. It is of course true that aforesaid observations are made in connection with the admission in MBBS and postgraduate course. And in the light of the question whether discrimination on the ground of place of birth would be countenanced under Article 15(1) and 2. However, the sweep of Article 14, read with Article 16(1), is no less pervasive. Article 16(1) ensures equality of opportunity for all citizens in the matter of employment or appointment to any office under the state. Article 14 declares that the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. The principles emerging from Article 14 and 16 are well settled. The object is to ensure equality to all those who are similarly situated. In other words, all the citizens applying for employment under the state are entitled to be treated alike. If that is so, it is difficult to appreciate how, having once allowed all candidates having minimum qualification of graduation in any medium to compete for the post, a further special beneficial treatment can be given to only candidates passing minimum educational qualification examination, namely graduation in Telugu medium, after their relative merits are assessed vis-a-vis other candidates in open competition. The similar is the provision here. After all things, then you get 10 marks. Reliance placed by learned advocates for the state of Andhra Pradesh and Telugu medium candidates on the decision of this court in the case of Sanjay Halwat is of no assistance, as on the peculiar facts of that case, the court held that weightage of 10 extra marks to the candidates who have graduated from medical college at Rohtak was not discriminatory or violative of Article 14. In that case, extra marks were found to be justified being awarded to local medical graduates for the purpose of ensuring that the medical facility in the state is not impaired in any way because of dearth of doctors. In order to attract residents of Haryana to postgraduate courses after they obtain medical degrees, this weightage of 10 marks was found necessary and reasonable. That was to ensure for the people of the state services of good doctors hailing from Haryana itself. It was also found that this weightage was based on domicile in Haryana or education at the medical college Haryana. This does not have the effect of shutting the doors of admission to the outstation boys. The aforesaid weightage of 10 marks was therefore justified on the peculiar facts of that case before the court. Such is not the situation in the present case. The aforesaid subclassification on meritorious candidates into Telugu medium candidates and non-Telugu medium candidates, insofar as the graduation is concerned, does not have any rational nexus to the object sought to be achieved thereby. If the object is to have a proficiency in Telugu language, which is the official language of the state, it has to be kept in view that even those candidates who have studied in non-Telugu medium like English or Hindi at graduation level also have to pass one compulsory paper of Telugu. It may be pointed out that the state had adopted, after passing the Official Language Act 66, three-language formula in the field of education. The students studying in other media are also required to pass a paper in Telugu language. Therefore, they have got working knowledge of Telugu. It has also to be kept in view that even after they are appointed to the post for which they compete, they have to clear the language examination before getting increment or even confirmation. And if they do not clear the examination, they are liable to be discharged. If that is so, proficiency in Telugu language at entry point pales into insignificance. So far as the recruitment to this post are concerned, it may be that the selected candidates concerned lower echelon of service may have to deal with public in Telugu or may have to correspond with other public departments or authorities in Telugu language, but that is well ensured by the requiring of passing Telugu language examination after being recruited to the post. Under these circumstances, giving a further weightage of 35 or 40 marks to such candidates even prior to their entry in service has really no nexus to the object sought to be achieved by such provision. It cannot be said that merely because a person has passed his graduation in Telugu medium, he alone is proficient in Telugu and not the candidates who has passed his graduation in other language. There may be cases that I am not just traveling while reading the entire thing, then kindly come to the conclusive decisions. For all these reasons, it must be held that the present rule of weightage to be given to a candidate who has passed graduation in Telugu is violative of Article 14 and 16 of the Constitution and does not represent any valid and reasonable classification having a rational nexus to the objects sought to be achieved. Now, the another judgment, my lord, this is a three judges bench again. 2005, volume 13 SCC.
ওইটা ভলিউমে নেই, এটা ভলিউমে নেই।
এটা যা
ওখানে নেই,
This one is not in.
ওটা ওর ইন্ডেক্সে নেই।
না, ওটা পরে দেয়া আছে।
পরে ঠিক আছে।
কত?
2005 13 SCC 721 2005 13 SCC 2005 13 SCC 721
Paragraph 11. Taking our findings as made herein earlier to the extent that the writ petitioner was entitled to sit and write the examination for selection of probationary officer in the bank, let us now proceed to consider whether the writ petitioner would be entitled to appointment in the post of probationary officer if successful in the written examination in view of the nature of the job to be performed as probationary officer. Before we deal with this aspect of the matter, we may take into consideration yet another aspect of the matter, namely, whether denial of permission to the writ petitioner to sit and write the examination for the post of probationary officer in the bank offence Article 14 and 16 of the Constitution. Article 14 of the Constitution guarantees to every citizen of India the right to equality before the law or the equal protection of law. The first expression, equality before the law, which is taken from the English common law, is a declaration of equality of all persons within the territory of India, implying thereby the absence of any special privilege in favor of any individual. It also means that amongst the equals, the law should be equal and should be equally administered, and the like should be treated alike. Now, here all are at the entry point of teaching job, similar. Then how can you give additional benefit of earlier teaching experience, which under the law you cannot give? Because there was no experience, the appointments being void. That what it forbids discrimination between persons who are substantially in similar circumstances or conditions. Yes. When in similar circumstances, you have to sit for the exam for job. It does not forbid different treatment of unequals. Article 14 of the Constitution is both negative and positive. Right, negative in the sense that no one can be discriminated against anybody and everyone should be treated as equals. The latter is the core and essence of the right to equality, and the state has the obligation to take necessary steps so that every individual is given equal respect and concern which is entitled to as a human being. Therefore, Article 14 contemplates reasonableness in state action, the absence of which would entail the violation of Article 14. Now, the paragraph 12 is also details discussion is made. I am not reading the entire thing. I would just only appeal to your lordship that kindly come to the 15 lines from the bottom. Under Article 16 of the Constitution, the general rule laid down is that there should be equal opportunity for citizens in matters relating to employment or appointment to any office under the state. The expression matter relating to employment and appointment includes all matters in relation to employment, both prior and subsequent to the employments. That I place this to show that what really Article 16 intends to carry forward for the principle of equality. Therefore, the Article 16 of the Constitution, what is guaranteed is equal opportunity to all persons. This qualification for recruitment to government service, and it is open to the authority to lay down such other conditions of appointment as would be conducive to the maintenance of proper discipline among government service. Like other employers, the government is also entitled to pick and choose from amongst a large number of candidates offering themselves for employment. But this can only be done in one condition, that all applicants must be given equal opportunity along with others who qualify for the same post. Well, I stop here. This is the basic principle. You are going for a public appointment. Teachers, they are not like any other job or profession. The teachers, they really create the nation. If at the end point of time they feel that we are out because we are not having some other qualifications, and what would the students feel? Nowadays, everything is transparent. Now I find some teachers are crying that our students are not respecting us. Why would they respect? If they find that teachers have got appointment through illegal means? And Article 14, 16 has to be complied with strictly. And particularly in this case, I would repeat, the direction of Supreme Court was only to fill up those posts which fell vacant because of the judgment of the Supreme Court. And he wanted to amalgamate. Now, this being the position, my lord, so far the কি
It was in whose favor?
না সেটা পরে আসছে ওগুলো পরে এগুলো now that the question would come I'm sure that another writ petitioner not this client though I was the counsel that's a different thing counsel doesn't have any cause there my lord this writ petition was moved let us see what was the issue and how the court dealt with that division bench judgment
I would
first of all the principle is that I am not bound by the judge with the best of respect Milord, definitely they can Milord, cite it as a matter of precedence. Milord, the precedent depends on whether the points are good and decided. Now this is settled law that even little bit of variation of facts, even one word, would completely Milord, change the ratio. Now kindly take Rashaka down. This judgment of Orunima Pal. Rashaka down. দিয়েছো
এর আগের দিন দেওয়া ছিল
আগের দিন দেওয়া ছিল বলতে হবে নাকি আর 2 মিনিটের সময় আমার কপি দাও
ওটাই দেখা পেজ নম্বর 24
তাহলে কাইন্ডলি
এটা সবগুলো একসাথে করা আছে স্যার সবগুলো judgment করা আছে স্যার পেজ নম্বর 24 ইন্টারনাল পেজ
তাহলে কাইন্ডলি কাম টু মিলট পেজ 2 The present appeal is directed against a portion of the impugned order, whereby the contention of the appellant that the recruitment process initiated in 2025 on the basis of the shade rules of 2025 could not be made applicable to the present appellants as they are to be considered under the recruitment rules of 2016 was rejected by reasoned order. So this was the issue. While considering this issue, the Honorable Court categorically records that
24
since the rules are not under challenge,
পেজ নম্বর 24 ইন্টারনাল পেজ 24
will kindly turn to shortcut corona. Page 24, the paragraph 34 of the judgment.
Second series of matters that we are working for. Go and matter. That's very feasible.
That's very interesting argument. Kindly turn to paragraph 34, the awarding of 10 marks.
Yes.
Awarding of 10 marks is an weightage to be given on the basis of experience that is only expected that in selection process of this nature of kind, all the candidates are required to undergo the rigorous selection process. Now, how the deepest of respect, court will not contradict itself. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks given to such candidates. So the first page says it should be considered contested by all candidates rigorous. And then section 10 marks weightage to given to such candidates. The object is to select and appoint an experienced teacher. That was not the advertisement. As rightly pointed out, learned Advocate General and also Mr. Bandyopadhyay, appearing for the commission, that the writ petitioners are not coming within the purview of the categories in whose favor benefits and concessions have been extended. The judgment of the Supreme Court, they are not extended in paragraph 49 of the judgment of the Supreme Court, they are not candidates selected in 2016 recruitment process. In the meantime, they have not also applied for service in any educational institution. It shall be the duty and responsibility of state to ensure quality of education, and the eligibility criteria should be framed keeping in mind the interest of students. But eligibility criteria did not mention even in the advertisement of the rules, that 10 marks should be given. If we accept the submission of so and so, then for the selection of the same subject teacher to different eligibility has to be applied. Well, deepest respect, this is just the other way. The eligibility criteria in the selection process 2016 is different from recruitment process 2025. Rules are more stringent and are student-centric. The revision in the eligibility criteria is in accordance with the consonance with the NCT guidelines, where I fail to understand NCT fixes some eligibility, minimum eligibility, nothing else. Anyway, therefore, here after considering all this, now the court says, when understood that this might lead to an incongruity, the court says next page.
That was previous.
The recruitment rules of 2025 has not been challenged by any of the appellants. Now I have challenged this. I mean, this petition has challenged this. Therefore, this judgment of division bench that will have no application even by the precedents in any way. Therefore, this judgment will not cannot stand in the way, and particularly after the last order of the Supreme Court, where the Supreme Court has made it very categorically that only the final judgment has to be considered. And final judgment says these are all void. And even on their modification application, Supreme Court says no benefit should be accrued to them. Therefore, if the 10 marks was open for all, then at the eligibility criteria, it would have been said that you must have teaching experience, so that the other experienced people could have applied. But here also, the well-settled judgment of the Air India Transport comes. Whatever you declare, there was issue second grade hoteliers and third grade were given, which he did not notify this. It becomes bad. But in this background, I sure the rules is ultra-vires and should be declared bad. And secondly, if your lordship, that is in item 25. But if your lordship is not with me, then what would be the interpretation of rules? Kindly come to page 39, the rules.
25 টা দিচ্ছি।
দাও যশোরকে আমাকে দিতে হবে না।
25 মানে
Item
নাম কি?
You are referring to the rules?
Yes, yes.
It is here.
হ্যাঁ,
So we can look at it.
এই চলে যান না আপনি
Rules.
পরের দিন বলতে পারবেন।
26, 25.
25 rules.
39
হ্যাঁ,
এটার পেজ
বলুন না।
39
হুম।
And then be followed by other advocates. May I have my lord?
ওটা ওই আসবো দেখাবো সব।
Personal ground.
All right, all.
I have to leave the court.
All right.
Thank you. Yes. I'll come back on Monday.
Yes.
আজকে শেষ হবে না।
এটা কি হয়েছে বলেছে ওই ইয়েতে নেওয়া। হ্যাঁ, 25.
হ্যাঁ, তাই তো সেটা অর্গানো বার করো। হুম। কি আছে? কি আছে? এইটা কি? এই ইস্যুটাই তো, তাহলে আবার কি দেখাবার কি আছে? Now, my lord's order was specifically referred by the Honorable Supreme Court. Lordship is well aware. I need not really trouble my lord with that. Therefore, the issues which are to be discussed are reflected and flagged in 7th November, 11th November, and 12th November, 19th November. I am really within the issues which was flagged by your lordship. Now, kindly come to me, Lord, the rule against. Without prejudice to the argument by the other petitioner that this is ultra vires. Now, if, my lord, some of the petitioners feel that if ultimately the rule is upheld, then what would be the
These set of petitioners are also freshers?
Yes, 25 and 44. Item number 44.
I'll come to the item. I am at the rule now.
yes.
He puts
Now, will kindly come to me, Lord.
2K and 12.
Of 25 rules.
Rule 2K,
সেটা কি এখানে ছিল না?
interview list. In respect of SLST means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit. But every word, not the statute makers do not waste any word. That's the principle. To be called on merit for oral interview and lecture demonstration. Category wise on the basis of preliminary merit. Therefore, you have to first fix up the preliminary merit, then invite them for interview and lecture demonstration. And what are the preliminary score? That is score from written test. The test for upper primary and traveling and academic score in the ratio of students. What is academic score? That is defined in, that is indicated in the advertisement. These are the eligibility clause academic score. Then after you prepare the preliminary merit, you call for the interview. Then final merit list. In respect of the SLST, a list of candidates prepared category-wise on the basis of merit, which will mean in addition, it's very categorical, whether the addition comes at this stage to what has been stated in the rule 21K. Marks obtained in oral interview, lecture demonstration, and prior teaching experience. Therefore, prior teaching experience, if at all, stand. The scrutiny of Article 14(16) can only be considered after the preliminary screening is over, not before that. This is at the final merit stage. What they are doing, they are giving additional 10 marks to hoodwink the meritorious people at the preliminary stage. Though rule does not permit so. This is my very categorical submission, and kindly also come to me, Lord, the schedule. Milad, again, I would say, Milad, the statute makers, Milad, do not waste any word. Schedule 2, written examination, WMR, then academics. Where in the parent rule, they say, Milad, academic. And why these academics? When you bring prior teacher experience, this is not really declared academic qualification. And you make it academics, even assuming this is part of academics, but this would not come when you are preparing the interview list. Therefore, 10 marks cannot be given, if at all can be given only at this stage of preparation of final merit list, to give them the handicap. That in our school days, someone was a little weak, he was given a handicap for a flat race. Then you are given 10 marks of handicap when you are really suffering. At what stage? At the final stage, provided you come across on your merit from preliminary test, which many of them could not. And yes, another word is very important, that is score. Merit score, academic score. Academic score, how it is asset? The educational qualification, 10 marks. And by percentage, you will get, if 60% above 10 marks, their merit score is mentioned. Below 60%, 8 marks. Below 50%, 6 marks. And what is the scope for scoring in teaching experience? That court is invited to give a harmonious construction and reasonable meaning. But unfortunately, I was shocked to hear that the authorities were arguing directly against their own rules. They said, no, 10 marks will go there. But the rule doesn't say so. Your own desire cannot change the rule. And like if your lordship wants not have the authorities to show that this statute has to be read not in its entirety, even without one single word, one single letter has a meaning that has to be completely followed. Well, today I will stop here. 2016 পাবে না তো বলে দিচ্ছি। No, my lord, there are authorities, I'm just, my lord, giving the, এটা দুটোর সময় এসে দেবো। May I stop it? Come
All
back to-
right, you want to come back at, all right.
দু একটা বাজে আর পাচ্ছি না। কবে?
As-
আজকে নয়
আজকে দুটো তো
আজকে দুটো থেকে সাড়ে তিনটে
My lord, for us, my lord, kindly keep it, my lord, on Monday.
All right,
Or
Let
my lord,
make-
there
let-
is one more-
let him make his submission.
Yes. But the other thing that I was suggesting, if somebody else, some other learned council wants to, my lord, challenge the validity of this rule,
It can be done.
they may
in one
all,
go.
yes, argue together. Let them conclude, then we'll make our submissions. Number one.
Some-
And number two, I don't know whether Mr. Bhattacharya is seeking any interim order or not. No, I'm seeking you. Well, in that case, kindly give us a week's time to come back with affidavits. No,
it has to be done by any means before 31st of December.
no, but the problem is, my lord, unless pleadings are, your lordship can very well appreciate it will not end over here. Therefore, the pleadings must be complete. We'll take the shortest possible time your lordship feels would.
All right, you have the copy of the Supreme Court order, the last one.
Yes, the yesterday's one. Yes.
Yes, uploaded yesterday.
Yes, yes.
The last paragraph of the order
Yes, madam.
Yes, adversely prejudice, yes.
as to what the High Court has to do, the court has mentioned.
Right.
Untainted candidates in the past selection are allowed to sit for the selection test to be held afresh. How
Yes.
do you accommodate them?
candidate, not.
List have not been published.
How do you accommodate? You have set the eligibility score, the age in such a manner
Yes.
that some of the candidates are out.
No, 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 no.
Yes.
I like this. My learned friend has placed the rules in his own way.
No, not in his own way. The age, as has been fixed in 2025 rules,
Yes,
right?
that is in terms of the Supreme Court's direction. Kindly have a look to the rules.
Hey, rules.
Yes. Please have a look to the rules.
Take the rules.
Page 2025 tables, page. ये वाला? Okay.
But it's at page,
49 টাকে দেখে যাও।
হ্যাঁ।
Para 49 of the Supreme Court judgment
Hmm.
says
Began with
age
no
relaxation for the
relaxation.
untainted
That
candidates.
does
Yes,
first,
yes,
So
yes.
age is
for the
taken care
Honorable
of.
Supreme
yes.
Court. And then.
Your
Honorable
lordship
Supreme
may kindly
Court
take
must
a-
order And then relax that.
So age relaxation
right.
is there.
Yes,
Yes.
para 49.
Score relaxation, score relaxation,
Your lordship may kindly take the rules.
right,
Rule 3.
right.
Is not for, my lord, with deepest of respect, my lord, not for the all the candidates who are the teachers. The candidates,
Right, right.
relaxation is not there.
Well, let there
One
not
thing
be any
is the
piecemeal argument, but I'll address your lordship in its entirety.
Yes,
I'll
that is the last order, that candidates, not the teachers.
Posed to him.
Yes,
Let him answer.
yes, yes.
Yes, he'll answer
The
because
real
this
sufferer
is
is the
the
waitlisted candidate.
direction of the court, Supreme Court on the High Court.
No,
So
no.
I just,
Milord, only the last paragraph may not suffice. Milord, the other orders are required to be, Milord, placed before your lordship. Milord, in bits and pieces, Milord, it should not be.
not in bits and pieces.
Because
There
all
are
the orders,
matters
Milord, all
may
the
not have
orders.
been served in all.
Sorry, I'm sorry, Milord.
You may not have been served in all matters.
No, I've made myself ready in the first matter.
Where the virus is challenged.
Yes, yes.
Yeah, I understand. But their commission will be there. They'll answer regarding some of the candidates. I'm getting matters who have been, who are not in a position to even appear in this election test because of the 25 rules. How will the court ensure that they appear? Keep in mind,
Very good.
this
very
is what is playing through the mind of the court, relying on what the Supreme Court has directed. Prepare. Commission is also here. They will also prepare. All right.
Milord,
2 o'clock.
Milord, 2 or 3 things, Milord, primarily, Milord, for the benefit of my learned friends, I'm submitting because on Monday they might
add on to my lord, what they have said today. Number one is, my lord, Supreme Court has fixed a timeline which cannot be extended by the High Court. Number one. Number two, my 2025 rules may be bad. Then also, my lord, 2016 rule will not revive. Neither will the 2019 rule revive. Because 2016 rule was replaced by 2019 rule. Now 2019 rule is being replaced by the
25.
2025 rules. Therefore, even if your lordship struts down, my lord, the 2025 rules, then also, my lord, 2019 will not revive, neither will 2016 revive. This is the second most important factor. The third most important factor is just the division bench judgment of Honorable Justice Shomensen's judgment. My lord,
Orunima Paul and Dolui.
yes,
Sanjay Dutt.
Yes.
yes.
Dolui.
Yeah.
These are, my lord, would be very three important aspects, my lord, on which, my lord, I will address your lordship, subject to the other ancillary factors.
So,
All right.
my lady will hear the respondent's side, untainted candidates on Monday. Is that the?
I do not know on Monday or not because the petitioner will start again at 2 o'clock.
Yes, my lady.
And the other petitioners also, I will hear them in one go so that the respondents
Yes,
can
that will be
answer
appropriate. Yes.
in one go.
For
And-
us, keep it on Monday, my lord. Maybe
Provided they finish.
Provided they finish.
if they
Yes,
finish,
yes,
very,
I follow.
very.
Might go to Tuesday.
All proceedings are live streamed. I allow visual appearances,
Yes,
the virtual
benefited
appearances.
from that.
So in case you are not able to come down, you
Yes.
can join
Or I
virtually
look forward
also.
to being in my lady's court physically.
That is
That
different.
Yes.
But then I cannot assure the
Of course, my lady.
timelines.
Of course, I
Right?
follow.
This is the reason I
Yes.
just
But in the
made my mind
Yes,
clear.
In the meantime, I also feel the prayer that made by learned Advocate General that now there are writ petitions. Now, at least there should be some pleadings on our part also.
Pleadings,
So that Lordships allows us if
affidavit.
because I don't want it to be delayed in any
Listen,
some kind
it
of
1 minute.
yes.
The hearing is continuing. In
Yes.
case anybody wants to prepare an
With
affidavit,
the
please come, hand over copies
Yes.
so that they can meet
Yes.
your
something on
objections.
record so that my lord
Very well.
become vulnerable later.
Because everybody knows the matter is not going to end here.
Correct,
Yes.
That-
Right,
that's the
it's going to go up. So let the pleadings be on record. The court does not have any objection.
Yes.
But then keeping in mind the timeline that has been fixed by the
Lordship
court,
continue.
I am continuing hearing.
Yes, my lady.
And in the meantime, you all can come up with your pleadings.
Yes.
Only
That's very
one
fair.
thing, appearing for the commission, now 18 is going on.
Cheryl
18 and 25.
18 and 25. I was just wondering, which of the matters the petitioners are going to make 18 and 25 only. No one else.
I,
Anyone else from the petitioners?
My lord, one more
as and when it comes up, take down note.
my lord, one
Right now, only 18 and
Like one
25 has
But one more technical aspect, the applications
Very
which
well.
are pending, Lordship may kindly have one formal.
you all have copies because all the copies are there in Sarthak. You all do have
that
copies.
we have, that we
Right.
do not need only one line so that if there is a requirement for us to go up, if there is a.
There will be.
Then my lord, no, my lord, what will happen?
Yes.
My lord,
Someone or the other
Now
will
then,
challenge.
my lord, because we are
Not-
now, yeah, our technically our status is now, we filed an applications, we are intervener and Lordship is hearing us.
I have
But-
mentioned in one of
Yes,
my orders that
yes,
I'm
you are. We are
hearing.
now
Division bench,
responding.
my lord,
We
division
were,
bench or the honorable,
Yes.
they have, it might be.
I am hearing the interveners.
Yes,
but
yes,
It might,
Malik.
it might be interpreted that Lordships have not allowed us to be a party. And Lordships is getting that the effect of it, in case Lordship takes the decisions against us, it will be extremely punished. So all I want,
No, no,
one sentence, the applications.
In that case, all addition of party
Yes,
applications are to be
27.
allowed
27.
and formally added, and you can come up with your own pleadings.
Yes,
Yes.
yes.
All right.
Yes.
Today this order will be passed
Grateful.
after I hear
Yes.
হিম সরকারের আগের দিন যেটাতে ভুল ঘটেছে
all the matter.
18 and 25.
Already 18 and 20.
earlier day my lord, all the order kept in him sarkar matter, that is 27 my lord.
All right. All right.
But
All right.
Just my note says 18, 19,
1 minute.
23, 24. 18, 19,
then 27 is a 10-mark issue.
No, all issues are clubbed
All
together.
issues, if it is being heard together, then those matters may be kindly clubbed together and make comments hearing from 2 p.m. What I am respectfully submitting, all these school service commission matters are not same. Some of them will not assail the rules. Some of them say, when 10 marks are to be awarded.
That
Some of
also
them-
That
comes
all three
within
together,
the rule.
all
That is-
together.
that group may kindly be clubbed.
I-
So that we all.
It is going on.
18, 20,
Absolutely.
26
It
from
is-
now. 27. Very nice.
Let the-
It is going on simultaneously.
18,
Please
24,
take
26.
note as and when matters are called. I
Only-
can
Yes, yes.
recollect.
Only difficulty is my
Other matters
applications
also
are
implicate these 10 marks.
the entire series
Other
is
matters
from
also.
18 to 44.
Yes.
Now we have filed applications in like 23, 25, 26, 27,
Let it be
34.
called on.
Yes, yes, my lady. Because even 23 implicates 10 marks.
Previous means
issue গুলো আমি প্রচুর ক্যাম্প সব ক্যাম্প গুলো
now which will be the lead matter? You all have to decide. I do not know which is the lead matter.
Item
Find out.
My lord, I beg.
27 and
I think everybody understood the basic issue.
Yes, the rules.
That we have.
Mr. Lahiri's matter is a different matter. He say no person, his case is, untainted teachers claiming no contractual teacher should be getting any 10 marks. That is his case, subject to correction. No,
No, that's a contractual.
only, the 10 marks issue, if it is to percolate, contractual teachers should not get. That is what I have gathered. Item number 41. If I am wrong, 41 is a different matter.
আগে ডিসাইড ফার্স্ট ডিসাইড দ্য whether
Let
10
us
marks is
decide whether the rule survives.
Yes, yes, madam. Yes.
And if the entire rule goes,
Then there will be no requirement.
then so let us wait.
Lordship decide the
10
rule
mark
first.
issue is there in the rule itself.
Yes.
Right? So
Yeah, it's fine.
all right, I hear you all at 2.
yes
My lord, I beg to mention, my lord, one.
my lord
We have a 3:30 today.
My lord, may I segregate one thing? My lord will remember the EWS issue. That is item number 24. My lord, it will, my lord, from
Be
this
separate.
bunch, my lord, on
This will be
Monday.
separate.
Monday, my lord.
Before.
No, 24 only.
My lord, I beg to,
24 on Monday, Mr. Bhattaji.
My lord,
24 on Monday.
Yes, 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 yes.
Item 24 on Monday.
Monday, because Mr. Bhattaji
All
has
right,
got it.
24 on Monday.
My lord, and my lord. Yes.
Sir, do not repeat prayers. I have heard. I have made what the court wants you all to
Yes,
know.
yes, understood.
24
my
on.
lord,
My lord, may I trouble your lordship with only one prayer? Your lordship might know, my lord, your lordship has been given the urgent determination of Justice Bibhash Pattanayak, my lord.
Yes, that is what I have signed in the morning.
My lord,
my lord,
but
I,
it has come to one knowledge. I could not have mentioned at 10:40 because it was
Yes.
not put to Sabha, my lord. There is one
Yes.
urgent matter. Mr. Bhattacharya, I have talked to my learned senior. He will not take
Justice
more than
Basu to
45
আমাদের
minutes.
45 minutes where? In this matter?
From 2 to in this matter.
All right.
He will conclude, my lord.
Ah.
Can it be little urgent? Last date
আজকে
is
তার
on
কার লিস্ট আছে
Tuesday. It was heard by
কেউ তো বসেনি
urgent
Yes, yes.
bench, my lord.
We gave the,
Just ordered.
Urgent determination based, and I have to pass order today, which will not be possible.
otherwise, my lord, matter become.
my lord, urgent determination, my lord,
The law has been settled by 2 coordinate benches as well as by the division bench. Whether pursuing candidates can
Participate in the selection.
participate in case.
Arindam Mukherjee.
Issue, my lord,
100%
is the last date.
Monday, you all can get it thrashed before the court.
Monday I will mention. Tuesday it will be taken up.
I'll direct the matter to be there in the list on Monday at the top. and mentioning your urgency so that the court
But
can
we
take it
will
up on
implement-
Monday.
Implement the urgency because
My lord, I
there
have
is already settled.
My lord, just to be listed, your lordship only passed that order from the
All right,
My lord, I just give the number.
this will come up in the supplementary
Malad-
list today.
Oh, similar.
Supplementary list.
My lord, Justice Pattanak's
1 minute. Supplementary. 325.
My lord, I have
Grateful, my lady.
Where is the file?
My lord, I'll kept in 7. My lord, I just get the number, my lord.
My lord, I too am mentioning one matter of Justice Pattanak's, my lord, item 3 today. My lord, extension, my interim order will expire on 30th, my lord. Today my matter was on item number 3, my lord. My lord, by the time the notification came, my lord, sat, my lord, I could not, my lord, mention. My lord,
You
it's
can
an
get it done
urgent.
on Monday only.
30th, my lord, I am getting skipped off my
My lord.
interim order, my lord.
My lord,
Extension of interim order টা নিয়ে নিন।
Extension of interim.
Mashan.
একটাই না না আমি ডিটেইলটা দিলাম এটা মেনশন
My lord,
The other side should be here.
দিয়ে দেবে
my lord, a similar matter. That is Mr. Bhattacharya, Mr. Dasgupta's special educator.
জিজ্ঞেস
Hassan Mondal matter, my lord. Mr. Dasgupta and I did.
Justice Patanayak.
Yes, my lord. Yes, my lord. We both, my lord, are good in that matter. Monday.
my lord, item.
One minute.
My lord,
Are the matters in the list?
Yes. My lord,
Item numbers.
item courtroom number 17, item number 6, item number 33 in Mr. Honorable Justice Basu's list, my lord.
I do not have the determination.
No, my lord, today, Honorable Justice Basu is not sitting, my lord.
Then I do not have Justice Basu's determination.
No. Urgency determination. And today, urgent matter.
আগে চেক করুন এই তো আর্জেন্ট ডিটারমিনেশন অফ বিভাস পটনায়ক
My lord,
Justice Basu
this
is not
my lord.
court
17,
court
17.
এখানে টানালেও
Item number 7 and 33.
আপনি
প্রথমটা 7 আর item number 33.
দেখে করবেন
my lord, my lord.
Item number 7
My-
and 33. No, 7 is sorry, 6. Sorry, pardon me, 6. Raju hence. একটু বলে দিই আমি একটা 6, হ্যাঁ 6. হ্যাঁ না 33 আমার 33 আছে ও But because this is
only
club,
direction will be
item number
that the matter will appear before Justice Patnaik on Monday.
এইটা একসাথে আছে
I will only place the matter in the list.
আজকে নিয়ে আসুন
But if the matter is already in the list, then what?
মানে
is the
urgency is that the last date
on merits, I'm not going to take.
on Monday itself.
How can we do it on Monday?
Right.
I have to mention it on Monday before Justice Pattanak.
So you want
Your lordship pass an order.
na determination. Five.
I'm only reminding
My lord,
Not on merit. Not on merit.
my lord, item 23, my lord, to be clubbed together with 18 and 25, your lordship's list. Mr.
Have a slip
Mr.
test.
Bhattacharya had been appearing in item 23 as well.
The matters are being taken on one by one. Just remain.
One indulgence, Your Lordship. The item number is 111, Your Lordship. If it is not heard today, the order will be in fact. The second SLST examination, Your Lordship, the reserve category change in general. The already Your Lordship heard yesterday.
My lord.
That senior Pratik was argued on this matter. Your Lordship, passed the order, Your Lordship. I am in the same sitting. I am also reserve category candidate.
Has the order been put up in the server?
No, not yet, Your Lordship. Kindly fix it to 2 PM, Your Lordship. It will take
PM, it's impossible. Let the order be put up in the server.
See, Monday is the verification day.
Oh, today I'll take it up.
My lord, the deficit.
Who's the commission must be there?
Yes, Your Lordship.
The commission.
He's a junior.
What is your name?
Lordship Danish. Mohammad Danish Faruqi.
All right. Which item?
Item number 111.
Please take note. Possibly one order was passed yesterday regarding the
WPA 26937 of 2000.
একটু দেখুন তো আমি দেখেছি কালকে সই হয়ে আছে
26937 of 2025. Same order, Your Lordship. Grateful.
My lord,
কি হয়েছে?
although it's a recess time, my lord,
একটা মিনিট দাও, my lord.
All right, let me.
my lord, item number 12. Item number 12, the CBI came here, my lord, at 1 PM. On 1 PM, my lord, they says that before recess, they take instruction from SSC.
I usually do it. কোর্ট ফিস জমা করেছি তার কাগজটা।
Yes.
আবার
Yes. এটা নিয়ে নিন।
it has to be no, it has to be in the file of the lordships. 14.
I'll fit.
Yes.
কি এসছে সার্ভারে? Yes, which item you said?
Item number 12, my lord.
12
I placed that matter, my lord. The OMR sheet is not.
Indeed, candidate.
Right.
If I may, keep your lordship noted. As an officer of this court, you are
Item
not
40 ধরার আগে একবার just আমায় ইনফর্ম করে দেবে। Anyways, I'll be here from 2 PM.
or rather, his OMR sheet was never uploaded the commission website. Now, during when this
Listen one thing. It is your data
lordship,
which has been forwarded to the commission and published,
lordship,
right? What data do you have in respect of page 42 where the petitioner's OMR is blank? This is the only candidate out of the 3,000 candidates,
478.
his
right?
serial is appearing as 2442,
Right.
where the numbers is been mentioned. Attend at it's not even zero, lordship. It is completely blank.
Blank. What does this blank mean? Where is his?
Has been what instructions which I have received from my officers is that possibly this is an error.
What
At the
error
end of-
on your part?
No, at the end of the commission.
What
because
is
my,
error?
Because my instruction says that he has attended, good, bad, indifferent, he has attended some marks, he has attempted certain questions.
Do you have written instructions?
Lordship, I do not have, if your lordship so directs,
Can I record your oral instruction?
Lordship, if your lordship so directs, I can produce it in the on Monday, lordship.
And the produce it. That's the
I can
suffice.
produce the OMR sheet.
You can produce the OMR sheet?
I
You
can-
have
if your lordship
copies?
can, if
Very
your
well.
lordship
That's
does-
good.
That's the suffice, my lord. That
Lordship,
will suffice.
one thing which I would like to bring it to your lordship's kind notice that despite several opportunities being rendered to all candidates across, whether tented, non-tented, when the honorable division bench of this honorable court presided by Justice Basak was in season of the issues of the matters, there all candidates were rendered opportunity of inspecting their own OMRs.
Physical inspection of OMRs.
Inspection of OMRs at the chamber of the advocate on record of the CBI. Lordship, despite that particular issue has been completely silent in this particular writ petition, whether
No.
he has applied for it or not, and whether he was rendered opportunity or not. So this is possibly what I'm trying to establish before your lordship, is that this is one of the loopholes of the petitioner himself, and he cannot claim
My lord, with deepest of respect, my lord.
Advantage out of it.
out of it.
Right. I
Yes.
get it. Nevertheless, since you say that you have a copy,
Yes.
please produce that on Monday.
Yes.
All right. Please come.
If your lordship can kindly direct so.
I'll direct. I'll direct. Item 12. Item 12.
Yes, my lord. Item
ঠিক আছে, ঠিক আছে.
number.
The petitioner participated in the RLST bracket NT, 2016 for Group C post. Though his name,
But I have received instructions from the School Service Commission in this matter.
yes,
The public being
But in item 12, I'm appearing for the commission.
right, what is the submission? Commission your submission please in item 12.
My lord, may I indicate one thing because that will help the court. My lord, in division, Honorable Justice Devanshu Bosak's judgment, my lord, in para 363,
I have some
para
issues.
3, my lord, that is specifically mentioned that OMR sheet available in the 3 hard disks, if not already done,
We have
or
received
such portion not done, must be.
for this candidates, we have received
Rahul, your voice is cracking.
incomplete.
Why don't you take instruction?
But for this candidate, we have received incomplete OMR sheet from CBI. Am I audible, my lord?
Incomplete OMR sheet. The CBI has the OMR and it will be produced in court.
Yes.
Acha. Okay. Though his name, comma, serial number, comma, roll number, published
Am I-
OMR marks,
There is some network issue, my lord. We have
and the
received instructions
difference
with
of
this.
marks
Milord, we have received the
have been
OMR sheet of this particular candidate. Milord, his
West Bengal Central
image of
School
OMR
Service
sheet is
Commission in compliance of the commission on 13th March 2023 in compliance of the direction passed by the court on 10th March 2023 in WPA 12270 of 2021, comma, the actual OMR marks is not reflected in the said list. Stop. The learned advocate representing CBI submits upon instruction that the OMR of the petitioner is available with the authority. Stop. Let the same be produced before this court on the
May I make one submission, Milord?
first.
My lord,
Milord, for this candidate, Milord, we have received a cropped copy of the OMR image from the commission. I am instructed that this is the copy which was furnished by the CBI with regard to this candidate. Milord,
The CBI will produce a
my lord,
copy.
one thing I just indicate one thing because of that, my lord. Because on that 13 March, in respect of 13 March order, OMR sheet is not uploaded of this petitioner. There is a specific, because that is a interim order for that advocate on records office. They can, but the final judgment, there is a, in subpara 3, there is a specific direction upon the SSC. I just read it, but 3 lines. Para 363, Honorable Justice Devanshu Bosak's judgment, my lord. OMR sheets available in the 3 hard disks, if not already done, or such portion not done, must be uploaded in the website of SSC forthwith and made available to the public for viewing. Till date, 2016 OMR sheet is not uploaded in the website.
Past order for
That is 2020 in respect of 2025.
25.
My lord, because of that, why is it is necessary? For 2 reasons. Why I make it? Why this is two reasons? Because of that, in this selection process, 2020 selection, 2025 selection process, there might be some candidate who even beyond the SSC's assessment, there might be tempted. What the reason of the uploading of this OMR sheet? The reason of that, transparency. But SSC not yet published it. Why? Because they want to hide it.
All right.
So they give the passage. First, they try to give passage to the tendered candidate.
All right. It's all
So, my lord, it will be kind enough.
Oh,
Judgment is there.
One
so
minute.
upload.
Milord, the direction of just
the OMR. in the public domain? Have you uploaded the OMRs?
Milord, there was no such direction to upload
Yes.
OMRs from your
Well,
lordship's order,
kindly
Milord. The
check it
direction
and
to upload OMR by the division bench, Milord, it merged with the Supreme Court's order.
yes,
And Milord, in
Supreme Court
Supreme
order
Court order,
upheld it.
there was no
I
such
just read
direction
it.
to upload
They
OMR.
hide
There
it.
was a direction to publish the tainted
What is
list.
the reason of
Milord,
hiding?
we are trying to upload the OMR of 2025 SLST pursuant to your lordship's last order, Milord. And the OMRs were also uploaded pursuant to the directions of the erstwhile division bench's order, Milord, until it was set aside by the Supreme Court on 8th of November
My lord. With the greatest of respect, my lord,
bench which
I want
remanded
to
the
read
matter
para
back to
45,
Justice
my lord.
Boshar.
Para 45, my lord.
But the current division bench has admitted that the order has merged with the Supreme Court order in the contempt proceeding. Milord.
It is margin Supreme Court order.
Provided the time of the court permits, it will be taken up. The matter is there in the list.
Beautiful.
rely upon 2011 5 SCC on the question of, my lord, the precedent, which could be precedent and what could be the.
একটা মামলা OMR sheet
Okay, বলো।
না না
What happened?
But I don't know. No, no, I don't know. Item number 12, Lordship, I was told that matter will be taken up now.
12.
I apologize. My instructions are not my lord because it has come from your lordship. When I was supposed to take it. After that, CPI is supposed to produce OMR sheet of the candidate concerned, as well as we have an answer string also. Under those circumstances, maybe come for you to go with that because the
Answer string.
Answer.
What is that?
OMR sheet is the same cropped OMR sheet which is being produced by the commission. However, from there, the candidate will not be in a position to decipher as to what marks he has obtained. However, answer string is, I have just learned the phrase now. It is the number of answers he has attempted and the marks which he is working. So from there, he can decipher as to what is the marks he got. And from there, it will be clear whether he was successful.
Whatever is required to be.
Give it to your lordship and let me open to my lord.
Yes.
On Monday. Because an others candidate, they give. But for this candidate, they're not giving.
They'll give.
Yes. I'm grateful.
Yes.
The 2011 volume 5 SCC.
Is it there in the compilation?
Yes.
Page বলে দাও দর্শক।
11 5 SCC.
Page 708.
Page number 7.
Yes.
They will kindly come to paragraph 32.
Page what? Page কত?
708.
Yes.
The paragraph 32, it needs a little emphasis that even one additional or different fact may make a world of difference between the conclusions in two cases, and blindly placing reliance on a decision is never proper. It is tried that while applying ratio, the court may not pick out a word or sentence from the judgment divorced from the context in which the said question arose for consideration. In this regard, the following words of Lord Denning quoted in so-and-so, but I am not reading the quotation. Now, this is the principle, my lord, which is accepted by Supreme Court. Therefore, the judgment of the division bench in a case where the issue was whether 2016 or 2025 would have no application as a matter of precedence. But this is one other, I'm not. In respect of the schedule to rules, what would be constitutional, my lord, implication? 2011 7 SCC, page 789. Here in the schedule that additional 10 marks was incorporated.
Yes.
The paragraph 16 is the background of the facts. The procedure for direct recruitment is dealt with in part 4 of the rules, which requires inviting of applications, scrutiny of applications, recommendations of the commission, disqualification for appointment, and selection by the appointing authority. Part 5 of the rules deals with the procedure for recruitment by promotion, with which we are primarily concerned. I'll not be troubling my lord with that for a long. Then kindly come to my lord paragraph 28. Rule 24(6) of the Rules 79 mandates that selection for promotion to all other higher posts or higher categories of posts in the service shall be made on the basis of merit and on the basis of seniority cum merit in the proportion of 50-50. In other words, 50% vacancies are to be filled up on the basis of merit, while remaining 50% in the promotion quota are to be filled up by seniority cum merit. The persons have to be within the appropriate position in the seniority list before they can be considered for promotion under the later category. Eligibility requirements have been specified under rules which candidates must satisfy to be considered under the seniority cum merit category. The other persons who are to be promoted to the post of DTO are on the basis of merit alone. Even if Schedule 2 of the rules does not exist, it is obligatory on the part of the respondent to evolve a methodology to make promotions purely on merit. Once the framers of the rules have intended to provide merit as the sole criteria of promotion, the appointing authority is not vested with the jurisdiction to waive the same or completely wipe out the same on a flimsy excuse such as one proposed in the present case. In the light of this, we now come to conduct the government which we cannot but help to comment upon. Right from so and so, no examination has been conducted by the appropriate authority, despite the fact that they also issued notifications for holding exams on few of these occasions. If there was a representation from the Transport Inspectors Union, it cannot be considered as a sufficient cause or reason for not holding the examination for more than 10 years and causing serious prejudice to the candidates who might have been sufficiently meritorious to qualify in the exam and be considered for promotion to 50% of the post under the promotion quota. It is a matter of regret that the government can take such a stand before a court of law and expect the court to accept such a submission. It is expressly untenable. Once the rules stand clear, the authority concerned is expected to act in accordance with the law and not default the law. One who defeats the law by his unjustifiable, unjustifiable act is liable for the consequences of the default. Now here, therefore, the schedule really destroys the principal rule that it must be on the merit and the selection method. Therefore, the schedule cannot be contrary to the statutory rules. This is the principle. Now, I come to the point that the persons whose selections have been declared null and void by the Supreme Court, they are untainted. They cannot get benefit Supreme Court judgment in another matter. This is 2003 Volume 2 Supreme Court cases, page 673.
Entry 30. Page number 467.
467.
Yes. I will kindly come to paragraph 2, the facts, which is quite relevant for the purpose of similar consideration. In the past also, allotments of retail outlets for petroleum products were cancelled by this court.
Which paragraph are you referring?
Paragraph 2.
All right, 2.
May I read once again? In the past, also allotments of retail outlets for petroleum products were cancelled by this court after coming to the conclusion that the allotments made were arbitrary on account of political connections, motivations, and extraneous consideration. The tainted allotments were also cancelled by various orders of the High Court of Delhi. The allotments which are on merits and not tainted were not ordered to be cancelled. It's a matter of coincidence that exactly 7 years ago, on the front page of Indian Express, a news item appeared regarding the grant of retail outlets for petrol pumps on account of political and other connections. Now, in August 2002, i.e. exactly 7 years later, again a news item appeared on the front page of the same newspaper about allotments to the near and dear ones of the political functions, attributing the same on account of political considerations. In common case, the court observed that for these allotments, a transparent and objective procedure has to be evolved based on reason, fair play, and non-arbitrariness. Now, this is the background. And now kindly turn to me, Lord, the relevant portions, paragraph 27 and 35. Paragraph 27.
Yes.
Article 14 guarantees to everyone equality before law. Unequals cannot be clubbed. The proposition is well settled and does not require reference to any precedent, though many decisions were cited. Likewise, an arbitrary exercise of executive power deserves to be quashed, is a proposition which again does not require support of any precedent. It is equally well settled that an order passed without application of mind deserves to be annulled, being an arbitrary exercise of power. At the same time, we have no difficulty in accepting the proposition urged on behalf of the government that if two views are possible and government takes one of it, it would not be amenable to judicial review on the ground that the other view, according to the court, is a better view. Then we'll kindly turn to paragraph 35, 36. From that paragraph 34. In the case in hand, that paragraph 34. The only reason for the Amas cancellation was that a controversy had been raised. There was no application of mind to any case. Admittedly, none of the cases was examined. In Silekha Vidyarthi, this court held that arbitrariness is writ large on the impugned circular. In state action, public interest has to be prime guiding consideration. In Silekha Vidyarthi case, it was held that the impugned state action was taken with only one object, in view, that is to terminate all existing appointments irrespective of the subsistence or expiry of the tenure or sustainability of the existing incumbents, and that by one omnibus order, the appointments of government council in the state were terminated. It was also noticed that no common reason applicable to all of them justifying their termination in one stroke or a reasonable ground had been shown. The position is similar in the present case. The expression public interest or probity in governance cannot be put in a straitjacket. Public interest takes into its fold several factors. There cannot be any hard fast rule to determine what is public interest. The circumstances in each case would determine whether the government action was taken in public interest or was taken to uphold probity in governance. The role model for governance and decision taken thereof should manifestly equity, fair play, and justice. The cardinal principle of governance in a civilized society based on rule of law not only has to base on transparency, but must create an impression that the decision making was motivated on the consideration of probity. The government has to rise above the nexus of vested interest, nepotism, and askew window dressing. The act of governance has to withstand the test of judiciousness and impartiality and avoid arbitrary or capricious action. Therefore, the principle of governance has to be tested on the touchstone of justice, equity, and fair play. And if the decision is not based on justice, equity, and fair play, and has taken into consideration other matters, though on the face of it, the decision may look legitimate, but as a matter of fact, the reasons are not based on values, but to achieve popular accolade, the decision cannot be allowed to operate. But after having learned the declaration from the highest court, which is again repeated by the court in last order, our order is final, that all these appointments are void. You are trying to give them appointment. Here, my lord, that's where paragraph 2 is placed. Some allotments were cancelled. You again wanted to bring them back to a different way. And that's this, my lord, Supreme Court says this is against. I'm tempted to not repeat this. The government has to rise above the nexus of vested interest and nepotism and askew window dressing. This was an attempt to window dress. The act of governance has to withstand the test of judiciousness and impartiality and avoid arbitrary or capricious actions. Therefore, the principle of governance has to be tested on touchstone of justice, equity, and fair play. If the decision is not based on justice, equity, and fair play, has to take into consideration other matters. Though on the face of it, the decision may look legitimate. But as a matter of fact, the reasons are not based on values, but to achieve popular accolade. Now, I am constrained to not make reference, Archie, that after the Supreme Court judgment, my lord, the highest governing authority said, I don't bother about Supreme Court judgment. I have methods to see that these peoples are taken back to the job. We can't simply ignore this. They are the public will. And court must take judicial notice of this fact. That's to accord the public accolade, if you say so, after having the judgment of Supreme Court, this is bad. And Supreme Court re-emphasizes on the last day, when all attempts are made to see that these appointments which are sought to be made are not interfered with by different applicants. And the next is, sorry, paragraph 45. Sorry, I missed it. The solution by reasoning to cancellation of all. Sorry, the solution by resorting to cancellation of all was worse than the problem. Cure was worse than the disease. Equal treatment to unequals is nothing but inequality. To put both categories, tainted and the rest, on a par is wholly unjustified, arbitrary, unconstitutional, being violative of Article 14 of the Constitution. It is apparent from the guidelines that the dealership and distributorship were provided to be given to the allottees as a welfare measure. Even in respect of open category, there's a limitation for the income, so and so, but that is in the fact of the case. Therefore, once they were cancelled, paragraph 2 have started, they are tainted. They cannot be put at par with the persons like freshers. And you wanted to bring them, giving the additional 10 points. These are all not in consonance with the constitutional governance. সবগুলো দেখার দরকার নেই তো, আমি জাস্ট I will just refer to the part of judicial review for the rules are concerned. 2024 volume 13 SCC1. But I am not piling up with the judgment on the same point. I'm just giving the relevant points. Page 1.
Entry number 9.6.
9C1. Page number 230. Only one.
Paragraph 105, state waive I am taking to lordship without placing the other paragraphs where deals with the constitutional authority in detail. I am not placing it. Therefore, I straightway come to the conclusion, paragraph 105. I got it.
Not yet. Which page do I get that?
Page 52 of the judgment.
Page 52 of the judgment.
Page 9.3.
Oh.
Paragraph 105, Lordship got it?
Which page in the compilation will it be?
Start from page number 230.
I got that, but paragraph 105.
Paragraph 105. No, that means
346.
346.
Paragraph.
Oh.
কি দিয়েছো তুমি?
হ্যাঁ, না।
এটা স্টেট অফ এইচপি তে অ্যাসোসিয়েট ডেমোক্রেটিক দিচ্ছ কেন? ভুল জাজমেন্ট দিয়েছো। Without ভুল জাজমেন্ট।
What is the cost title?
The state of Himachal Pradesh versus Yogendra Mohan Shenko. 24-13 5 পেলে। No. 24-13 SCC page 1.
The citation it is
2024 volume 13 Supreme Court cases.
Yes.
Page 1.
All right.
State of Himachal Pradesh versus Yogendra Mohan Sengupta.
All right.
The judgment of the just the retired Chief Justice. I'm just read out loudly.
Yes.
It could thus be clearly seen that this court, even when a provision in the Constitution enabled Parliament to make a law, thereby excluding the powers of judicial review, except under Article 136 of the Constitution, held that the power of judicial review vested in the High Courts under Article 226. And this court under Article 32 of the Constitution is an integral and essential feature of the Constitution, constituting part of its basic structure. And therefore, the power of High Courts and this court to test the constitutional validity of legislation can never be ousted or excluded. This court further goes on to observe the power vested in the High Courts to exercise judicial superintendence over the decisions of all courts and tribunals within their respective jurisdiction, also a part of the basic structure. And always a point is sought to be taken that these judicial reviews beyond the purview of going to the policy decision. Here, this is good. No. This is the basic structure of the Constitution. Though the Constitution enabled Supreme Court only under 136, this court says no, this power is vested with the High Court under Article 226 also. Therefore, this court not has a power to interfere. And while summing up on these points, another important judgment I feel is necessary. But once a statute was declared violated by the Supreme Court, but subsequently again, when the matter went up to the Supreme Court declared that ultra vires. Supreme Court, it is permissible. This is a constitution, is a dynamic document. AI 1986 Supreme Court.
Page number 1.
I'm sure the many voices would come that the justice mentioned in division decided so and so, therefore you can't do this. Though according to me, Justice Shane Millett had no occasion to deal with this. But this is AI 1986 Supreme Court 1444. This is corresponding to 1986 Volume 3 SCC, page 385. These principles have been reiterated later also, that I have not brought those judgments just to show that this is the basic judgment. Joshua, SCC দিয়েছো?
এখান থেকে করবেন প্যারাগ্রাফটা ট্যালি করবেন।
না আমি ভর্তি বাইরে এখান থেকে। Not the paragraph 4 I shall rely upon. The paragraph begins with this counter affidavit. The counter affidavit does not explain why any distinction should be made between residential and non-residential buildings in the matter of affording the protection of provisions of the Act. To say that non-residential building is different from a residential building is merely to say what is self-evident and means nothing. Tenants of both kinds of buildings equally need the protection of the beneficent provisions of the Act. No attempt has been made to show that the tenants and non-residential buildings are in a disadvantageous position as compared with tenants of residential buildings, and therefore they need greater protection. There is and there can be no whisper to the effect. To illustrate by analogy, it is not enough to say that men and women are different and therefore they need not be paid equal wages even if they do equal work. The counter affidavit has repeatedly referred to the weaker sections of the people and stated that in order to protect the weaker sections of the people, a distinction has been made between so and so. It is difficult to understand how the exclusion of tenants who pay higher rent from the protection afforded by the Act will help to protect tenants belonging to the weaker sections of the community. It is one thing to say that tenants belonging to the weaker sections of the community need protection, and altogether different things to say that the denial of protection to tenants paying higher rents will protect the weaker sections of the society. Further, the distinction suggested in the counter appears to be quite antipathic to the actual provision because, as we pointed out earlier, there is no such ceiling in the case of tenants and non-residential buildings. Therefore, a tenant of non-residential building who is, I just skip over the facts. And then we must also observe here that whatever justification there have been in 73, when Section 30 was amended by imposing a ceiling on rent payable by tenants to residential buildings to entitle them to seek a protection of the Act, The passage of time has made the ceiling utterly unreal. We are entitled to take judicial notice of the enormous multifold increase of rents throughout this country, particularly in urban areas. It is common knowledge today that the accommodation which one could possibly got in 1973 will today cost at least 5 times more. In these days, the universal day-to-day escalation of rentals, any ceiling such as so-and-so is totally artificial. As held by this court in such and such, a provision which was perfectly valid at the commencement of the Act could be challenged later on the ground of unconstitutionality and struck down on that basis. What was once a perfectly valid legislation may, in course of time, become discriminatory and liable to challenge on the ground of its being violative of Article 14. After referring to some of the earlier cases, Venkataramaya observed, the garb of constitutionality which it may have possessed earlier has become worn out, and its unconstitutionality is now brought out to a successful challenge. Therefore, if I may proceed, it's my duty. Sri So-and-so and Council for Tamil Nadu invited attention to some sentences from So-and-so, where referring to section 30, before it was amended in 73, it was observed, clause II exempts any residential building or part thereof occupied by any tenant if the monthly rent paid by him exceeds so-and-so. Hence, the object of legislature clearly was that the protection of the beneficent provisions of the Act should be available only to small tenants, as they belong to the weaker section of the community and really need protection against exploitation by rapacious landlords. Those who can afford to pay higher rent would ordinarily be well-to-do people, and they would not be so much in it so and so. These observations were made in 74, soon after the amendment of Act in 73. They were made in a different context and not in the context of a challenge to the vagaries of the provisions as violative of Article 14. As we pointed out earlier, the argument based on protection of the weaker section of the community is entirely inconsistent with the protection given to tenants of non-residential buildings who are in a position to pay much higher rents. We are therefore satisfied that section 32 be struck down as violative, which was earlier declared valid, now declared valid. Therefore, the Constitution is a dynamic document. It requires interpretation from time to time with the change of society and development. And again, in this case, conscience would prick. Judicial conscience, of course. The large scale of corruption, the entire selection having been set aside, an attempt was made to bring them back through back door. We, the freshers, cannot be equated with the persons who are found to be tainted and given the same door to entry, and that to giving an additional advantage. That's why this is unconscionable. These are my points, Milord. No, Milord, anyway, this is not required even then. That if the government, Milord, wants that the selection had proceeded, let it proceed, Milord, without this 10 marks benefit. Let them be brought on the same level and let them be adjudged on merit. Let us see, Milord, who is found to be meritorious. The ultimate purpose is to choose the meritorious person for the purpose of teaching, and that merit must be on the basis of, Milord, the entry door eligibility. Nothing from back door. Now, these are my submissions.
So would you restrict your submission or the challenge primarily to the 10 marks? If this 10 marks goes,
Milord, the rules, Milord, makes eligibility clause as the entry point. That should, Milord, be treated as a level playing field all throughout. These additional 10 marks, Milord, the percentage of the merit could be adjusted, or should be seen on the basis of the marks of 10. 60% you get higher marks, 30%.
this I understand, but this will be one set of candidates regarding the 10 marks. There is another set where the eligibility marks 60% or 45 or something has.
That has been made. Look, my challenge is all throughout. But confusion create. My challenge is all throughout. First, let the entire rule should be declared ultra vires. But
Yes.
these are not in consonance with the standard
Supreme Court
practice.
judgment
And the Supreme
also.
Court is not done also. But if an appeal is made, let there be some workable solution. It may also happen. then the workable solution can only be made without awarding 10 marks, which is an additional boost. Though they are not entitled to participate.
Right. What will happen to those candidates who could not participate in the recruitment process because of the alteration of the
That's why
marks?
after this is declared, I said the first point, because I didn't think it should go. There should be a clean slate. It should be completely de novo. That is my first plank of argument. These are alternative arguments, Milord, depending on the situation and the
I would like to hear the other petitioners also.
Because these 2016 candidates, Milord, are not entitled to participate. That's my, Milord, first point. In view of the Supreme Court judgment. None is entitled to get without any benefit because their appointments are void.
No, at the same time, the court directs for conducting a separate recruitment process for them.
For the vacancies.
Yes.
Which was available then.
Right.
If you had undertaken the exercise of filling up 2016 vacancies, there was no difficulty because the candidates who had appeared all at the same point, they would have been contested. Now you have created this trouble. Now,
what was the declared vacancy in 2016?
Not in 2016, declared vacancy was
around 12,000 and 5,000.
Vacancy
12,910, 12,915 or 5,700 something.
Yes, 12,500. I think that's available. The state can also.
All right. And in 2025, the vacancy has increased.
1,400.
Milord, in 2016, Milord, the vacancy, may please to Milord, note it down. 2016, it was 12,905. So for 910. In 2025, it is 23,212.
Classes 9 and 10?
9 and 10.
All right.
And then for recruitment to class 11, 12, 2016, it was 5,712. And in 25, it is 12,514. But I am not troubling now Group C and Group D. That will.
No, that is not.
And I am told, Milord, this is mentioned in the requisition.
All right, all right.
Paragraph 8.
All right, all right.
Paragraph 23. Paragraph 8.
বলেন কোথাও বলেনি তোমার কিছু ঠিক মতো পড়ো না Supreme Court judgment. I'm just not at the risk of repetition, reading out the Supreme Court judgment. প্রথম যেটা পেশ করেছিলাম কোন কেন কিছু যখন আর্গু করি মাথা থাকে ডিভিশন বেঞ্চ চাইছি না আমি সুপ্রিম কোর্ট চাই প্যারাগ্রাফ 20 Paragraph 19, Milord, the following principles emerge from the aforesaid discussion. Supreme Court.
Paragraph 19 of the Supreme Court judgment.
Yes.
All right.
Page 76.
All right.
When an in-depth factual inquiry reveals systematic irregularities, such as malice or fraud that undermine the integrity of the entire selection process. Milord, I have been repeatedly trying to highlight this. The result should be cancelled in its entirety. How about if, when possible, segregation of tainted and untainted candidates should be done in consonance with fairness equity? The decision to cancel the selection en masse must be based on the satisfaction derived from sufficient material collected through a fair and thorough investigation. It is not necessary for the material collected to conclusively prove malpractice beyond a reasonable doubt. The standard of evidence should be reasonable, certainty of systematic malice, the probability test is applicable. Despite the inconvenience caused to untainted candidates when broad and deep manipulation selection was proven, due weightage has to be given to maintaining the purity of the selection process. Individual notice hearing may not be necessary. This is the legal finding, and then, in our opinion, this is a case where the entire selection process has been very vitiated and tainted beyond resolution. But what is the impact of this? Manipulations and frauds on a large scale, coupled with attempted cover-up, have dented the selection process beyond repair and partial redemption. The credibility and legitimacy of the selection are denuded. The High Court has referred the illegalities. I am not troubling my lot with that. In this background, now the directions come at conclusion, paragraph 45. After having those legal findings, now the question comes to the Supreme Court for relief. And while relief may not, the Supreme Court has exercised the power of Article 142 also in few cases. I should have that. The asked questions relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of tainted candidates were appointed must be terminated and they should be required to refund salaries, payments, and so. Their appointments were the result of fraud. This amounts to cheating. Therefore, we see no justification to alter this direction. First, so for the tainted categories list have not yet been published. Supreme Court has directed this court to ensure the list is published. Nobody slips in. And for candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to egregious violations of illegalities which violated Article 14 and 16. But if the selection is set aside on the ground of violation of the constitutional provision, the constitutional body cannot take a turn around and say we'll throw them back door. Therefore, these people also does not have any right. That's why I had cited the judgment of petroleum dealers, which was once set at naught. The Supreme Court said you cannot bring them back and put it at the same plane that of the untainted people. Therefore, this is the position, my lord. I would therefore appeal your lordship, my lord, can you consider the entire aspect and ensure that the selection process for teachers are made, my lord, absolutely beyond reasonable doubt to instill confidence in the minds of the, my lord, the society, which is much more important than any other thing. Deeply honest.
The other petitioners.
I was appearing in item 27.
No.
27?
Judgment.
Which item?
Disable. 49 disable. না পড়ে বল না পড়ে কেন আমি বলেছি দেখেছি সব আর্গুমেন্ট হয়ে গেছে এখন লিস্ট বার করে এটাই তো হচ্ছে টেন্টেড লিস্ট গুলো really I'm prompted to make this submission that unless the tainted list, the tainted categories have been defined by the High Court, but they must come out honestly with that list. There are appointees who got appointment after expiry of panel. That is also under the tainted groups.
I have passed an order.
Yeah, you have passed an order.
Yesterday.
Direction
এটা তো ডিরেকশন আছে প্রকাশ করে
Has that order been uploaded? Not yet.
No. Yesterday's order not uploaded.
Uploaded. Yes, only the list to be.
Here from the date of publication,
Their names should be.
Now, when the division bench judgment was upheld in toto, there was direction that OMR sheets available in the third hard disk, if not already done, such portion not done must be uploaded in the website of SSC forthwith. But that is also necessary. And in fact, the Supreme Court, bestowed responsibility on this court to ensure that this is done.
Which portion did you read out?
Now, this is division bench judgment, paragraph 363. 363.
363 division.
Right.
bench judgment.
Roman III.
All right.
কোনো অনুমতি দেয় না তো বুঝতেই পারবে না তো আমি সেটাই বলছি
Yes. Item 27.
So far as my case is concerned, the petition is saying the challenge is only restricted to
Commission
award of,
item 27. Item 27.
award of 10 marks for prior teaching experience. That is the only challenge which has been thrown to the rules. So that I will be adopting holistically. Mr. Bhattacharya has already submitted. I'll be adopting his submissions only, my lord, with the rider that the petitioners here in my lord, they do not want stalling of the entire selection process. They intend to have the selection process based on 90 marks because this 10 marks, this is my lord, first of all, this is
Are you all freshers?
we are freshers, yes. We are
Correct.
freshers. Our case is, my lord, that
So
the
this
minim-
case has been highlighted and your prayer has also been
is
submitted.
only, my lord, a few additions. I'll just analyze, my lord, the rules, my lord. Rule 3 of, my lord, the 2025 rules that prescribes the minimum age to be 21 years. So, my lord, granting entry to applicants who are 21 years old and thereafter a rider that you have to, if you have 10 years, you'll get 10 marks for teaching experience. That is absolutely absurd. So this is one, this is basically, my lord, nothing but a sanctimonious approach and attempted sanctimony to show to the society at large that this is a transparent selection process. But actually this process is intended to benefit a particular class. So there is no intelligible differential and this is hit by, my lord, articles 14 and 16, my lord. Then comes, my lord, the basis of selection rule 6, my lord, kindly marks the only basis of selection is merit. But they are indirectly, my lord, clubbing it with seniority. It's merit comes seniority because someone who has 10 years of teaching experience, he cannot be 21 years old. He will be minimum 31. And he will be getting that benefit. So it is restricted to a particular class.
Yes.
And third is, my lord, this prior teaching experience. They have had, my lord, earmarked 10 marks for it. My lord will find it at page 42 of my petition. That's the schedule, the second schedule. There is no provision, my lord, in the forms also for indicating prior teaching experience. So this is nothing but an afterthought.
There is no provision in the form.
No, there is no provision. I did not find form provision.
Submission is that only if you fill up the form, then only the same is reflected.
Forms have to be submitted online.
Yes.
Yes. And no, how many years duration, that is not there in the form, as far as I found out.
Experience is there.
In any event, my lord, leaving that point, my lord, if we take, my lord, the notification, page 46, it speaks about, my lord, not only the vacancies existing as on that day, but also, my lord, the fresh vacancies, my lord, that may be notified. So they are clubbing everything together and eliminating competition by incorporating this 10 years, my lord, this 10 marks for teaching experience. This is, my lord, hitting directly on the principles of equality, my lord, as envisaged under Article 14 of the Constitution of India. As well as, my lord, it's also defying the rules. Because Rule 3, my lord, is a stumbling block, as well as, my lord, the basis of selection, my lord, that is Rule 6. Manner of selection. Selection shall be made category-wise on the basis of merit in the manner specified. So if merit is the criteria, you cannot obfuscate the issue by incorporating a teaching experience and earmarking extra marks. They are already TET qualified. Now the Honorable Supreme Court very recently, my lord, insofar as, my lord, the outgoing teachers are concerned, who are about to retire, the Honorable Supreme Court has laid down that no, you have to do a bridge course insofar as TET is concerned. It's teacher. The TET is earmarked to be, my lord, a test ascertaining the standard of teaching of a teacher. But this will be like a double jeopardy to benefit a particular class, singling out, my lord, the mass in general, my lord, who are participating. So these are, my lord, my submissions, my lord. The prayer is restricted to, my lord, having the test at 90 marks, my lord.
10 marks, yes. And there are others also.
Because of that, my lord, item number 18, item number 18 and 19, my lord. That 19.
1 minute.
Man, I am
1 minute.
item number 19.
কোত্থেকে শুরু হলো আমাদের? 18.
18.
All right, 19, yes.
19 is mine, my lord.
Yes.
The 19, who are they, my lord? The petitioner, they are the participant of 2016 selection process.
19.
19. 19 can.
18. এটা হচ্ছে 27. এটা 27 কে আলাদা রাখুন। আর 19টা দিন। Yes. Item 19.
Yes, my lord. Who are they, my lord? First, I expose the who are they, my lord? All the petitioners, they are the 2016 participant candidate. And they are the wait-listed candidate, who are the actual sufferer. First time, my lord, why they become the sufferer? The act of the state government as well as the SSC and board, due to their executive work, we are the sufferer, first time sufferer. Now, my lord, after this suffering, the apex court, my lord, give the judgment, and judgment already placed and vividly placed. There is no such mentioning the who are the beneficiary of 2016, give the extra weightage. We are the actual sufferer. We are the wait-listed candidate. Due to governmental corruption, we did not get the job. Now the second time we again appear, we get 100% marks. Again sufferer. Why? First time due to their executive work. Second time due to their legislative work. Subordinate legislation. So governmental intention. What is the governmental intention? First time, these three Article 12 authorities.
No, you participated in the 2025 also.
Yes.
But then the 10 mark is troubling you.
Yes, that's the troubling
All right,
point.
so 10 marks have been argued.
Yes, that's my point. Why I challenge it. So that is the reason. So first time we suffer due to their executive work.
All right.
And second day, this.
Next.
Item code.
Acha, 1 minute. Take down an order in item 18.
18 and 25.
Are submissions made on behalf of the petitioners. Stuff. The recruitment rules, 2025, pursuant to which the ongoing selection process is being conducted is challenged. The applications have been filed seeking addition of party stuff. As any order passed in the instant writ petition may have cascading effect on the others, accordingly, the applicants be added as party respondents in the instant writ petition. The department is directed to make the necessary amendment in the cause title of the writ petition. It will be open for the applicants to file affidavit in opposition to the writ petition. The petitioners would be entitled to file a reply thereto. List the matter for further consideration on 1st December.
But 18 and 25. 18 and 25. 18 and 25.
No.
18 and 25.
25.
26.
My lord, if the as submitted by my lord accepted, the rule is after my lord, then it will be after interview and
The stage It is the stage at which the 10 marks is to be given.
And my lord, the 2016 candidates are not entitled to the marks. Because the entire selection was declared null and void.
That's our contention.
And my lord,
That is in the first matter also.
my lord, another thing, my lord, probably your lordship was referring to item number 18, that addition of party subject to correction, the
It would-
addition of party applications in subsequent matters, not in
My lord, item number 27.
18, there is an
Yes,
application I can.
18 is there is also application as well as 27. There are several applications.
I'll come one by one. 25 was taken up. That is
18 and 25 has been argued by Mr. Bhattacharya. That is what we have taken note.
25. এই orderটা 18 and 25 appearances will change. Petitioner's appearance will change. Mr. Bhattacharya remains.
No, no, my lord, it depends on respect. My lord, 18, my number is, my lord, all the matter, my lord, Mr. Bhattacharya appear. 1890 already I handed over. Last occasion, Mr. Bhattacharya appear in Bhim Sarkar matter. 27. I just give the number one after another because.
1 minute, they should also know.
Yes, yes.
19 also argued.
Yes.
তাহলে 19 টাও দেবেন লিস্টে।
My lord, I just give the number 18, 19, 27.
1 minute, 1 minute, 1 minute, one by one. 19,
19, then
same
27.
order will go down.
Yes, yes.
1 minute, 19 এ there is no application. There is no লিস্টটা দেখবেন কিন্তু application নেই 19 এ। All right. 20, 20, who's there in 20? Yes, is it not related to? I'll take it up. Wait. 21. Is it SSC matter? Separate matter. Please wait. Just wait. 22. Not the same matter. 23. Same. Application is there. You're for the petitioner. Same order will go down.
I have agitated another point. That
What is the point?
some of the candidates were appointed even after the expiration of the panel.
Expired.
They have not come under,
Expiry of the panel.
yes, Lordship. They have come under as untainted and they are set for the exam. Lordship.
All right. 23.
Yes, Lordship.
23 application allowed. একটা line 23 তে add up করবেন। সেটা হচ্ছে the petitioners
The same steno hai.
apart from the challenge to the virus of the 2025 recruitment rules, comma, the petitioners have also challenged the action of the commission in not publishing the list of candidates who were appointed in the 2016 recruitment process after expiry of the panel.
My lord, that is also that is mentioned.
Was kept on 10 December.
The commission is directed to publish the list of candidates who were appointed in the 2016 recruitment process after expiry of the panel. ঠিক আছে? Release the matter on 10th of December. It's fixed on 10th, you say? 10th.
Remember all these matters.
10th.
Item 23, one observation go down, Lordship. That is the panel of class 9-10. It had expired on 12th.
Oh, it is there. It is earlier order, it's there.
And also,
It is his matter. Let him say yes.
this indication is there in
The dates,
expired. Yes, Lordship.
dates when it expired, give the dates. Please, নিয়ে নিন তো একটু।
12th March 2019. For
The-
class 11.
The date of expiry of the panel in respect of classes 9 and 10 is
12th March 2019.
12th March 2019. And the expiry date for the panel in respect of classes 11 and 12 is
27th November 2018.
27 November 2018. All right.
I'm led by Mr. Bhattacharya and Mr. May
You are?
led by
put it down. It is not possible for the court to memorize. A slip should be there, so it will be tagged in the file and the appearances will be recorded.
Elections made by your lordship was to give the list of the persons who have been appointed after the date of expiry of the patent. Because lordship has not yet decided that we are.
Yes, this is what has been directed. All right. Yes. How does it matter whether it is published or not? Yes.
Ultimately, we are not able to persuade your lordship that we are not tainted at all.
Yes.
Once there are societal issues, we will not be able to get it back. All I have is
আচ্ছা ঠিক আছে, পাবলিকেশনের জায়গায় প্রোডাকশন, যেখানে বললাম না যে পাবলিকেশন অফ দি প্যানেল, ওটাকে প্রোডাকশন বিফোর দি কোর্ট।
প্রোডাকশন
হ্যাঁ কোর্ট কেস কোর্টের কাছে পাবলিশ
ওটা কি আগেরটা হবে?
You are submitting something. Is it in respect of this? Is incorrect?
No, not in.
No, not in.
Only one recording, my lord. This is according to the petitioners because in the Supreme Court, by the SLT has filed a report with the matter was going on, my lord. They are taken the different date of
Item 23 কি নাম?
All right, this is the petitioner's submission.
Item 23, Kiran Dev Sharma.
According to the petitioner, the date of expiry of channel is such and such. ঠিক আছে? This is 23. All applications are allowed.
তুই কি জানতে চাইছিস? আমি জানছি, বোঝার চেষ্টা করছিলাম।
My lord,
order upload করেছে কিনা
ঠিক আছে?
my lord, in the earlier matters, it was ordered, it was directed to be published. So should we, yes, my lord, the ones that have been kept on the 10th of December, it's not uploaded yet, but
Let us see the order.
it was to be published. Yes, we have been directed to publish.
That's a different thing. I'm saying
No, you
that
must
is the expiry of panel.
Expiry panel only, sir.
No. Commission was directed to produce the list, subject to correction of the general senior.
I'll check up my order.
Commission was directed to produce the list, not publish the list.
Intention was to publish the Weimar sheet as well as
Something else. Something else.
OMR was published. OMR published.
Produce হয়ে গেল. Now he's telling.
All right. 24.
24 is fine, my lord.
Sorry,
EWS, my lord.
no, my junior gave me a different.
Oh, 24th is fixed on Monday. 25 order recorded. All right. 26. Yes, please come forward.
24th কি হলো?
25 is going down with 18.
Yes, Rahul Mandal, I don't have.
one thing in 25, my lord, I am not challenged the virus of the case.
আচ্ছা 25 এ তাহলে ভাইরাস অফ দি রুল চ্যালেঞ্জ হয়নি।
Okay.
ঠিক আছে?
I don't have.
25 এ অর্ডার লিখুন যে the matter এর
Same. Rahul Mandal is also same.
possibly in the last day's order it has been recorded
But
what the
mark
challenge
when it
is.
will it be added?
Challenges,
That is recorded in the last
Yes,
day's order.
but
They are
the
not
real
reading.
minor is
Lordship
at
is
what
not
day?
required.
Yes,
25
the
related to
stage.
what
Yes,
day?
yes.
26.
HUD
Rahul
submission made on
Mandal.
behalf of the
We same. When will have?
release for
Experience
further
last week.
consideration on first.
25.
Yes,
There is no
25, 26.
application.
Same.
Application নেই, শুধু এইটুকুনি অর্ডার হবে।
26 challenged, same order,
have-
my application also. So same
18
as 18. Yes.
virus challenge. Acha, same order as 18 will go down in 26. Your no application I see can.
Yes. All these matters. My lord,
26 there is no
No, I
can.
don't have this one.
yes, my lord. But there are applications. There.
When did you file?
It was there, my lord.
5.
Yes, it was hard. My learned friend was there also.
This is Rahul Mandal.
Yes, this is Rahul.
ক্যান গুলো কিন্তু লিস্টে নেই। চেক করে নিন একটুখানি ক্যান আছে কিনা। In case there are applications,
Those.
please file, make it ready.
Yes.
The list does not reflect the can today,
My lord.
so
some
the
of-
orders are not there. You Make
Do it.
yourself ready
That do-
and similar orders will be passed.
Correct.
যদি ক্যান থাকে, অনিমেষ বাবু যদি ক্যান থাকে সেগুলো কিন্তু ওনাকে জানাবেন, add হবে। ঠিক আছে? যদি ক্যান না থাকে ক্যানের কোনো অর্ডার দেবেন না। 27
yes.
27 can is there.
এটা নিন তো ক্যান
Cans allowed. না জিজ্ঞেস করি, will it be same as 18? Why is challenged?
I am the additional, I file additional party, my lord.
Who is the petitioner? 27.
Mr. Bindodal Bhattacharya was there. Mr. Bindodal Bhattacharya appeared, right?
Oh, 27 have.
This is my matter.
Ha.
There were 10 marks challenge is there, virus challenge is there, led by Mr.
29
Bhattacharya.
All right.
আছে না?
Same as 18.
29
18 মতন হবে, all cans allowed.
29,
28.
My lord, 28, my lord, the matter relates to whether part-time teacher are entitled to those states.
No,
28
the ones that in the morning are adjourned for
And
another
previously,
day.
your lordship has
This has not been argued at all
28 এর নাম কি?
Shongita Das.
today. Today it has not been argued. So I'll post it later on.
Well, around 29 second.
সেটাই তো বলছি 29 second.
Main is if the it is
Everything in item 26, Rahul, where the can is not being shown, earlier order.
can is
was
there.
An order was passed also, can was.
Oh, then it is
Maybe
there.
was just some mistake.
ठीक है, if the can is allowed, then there is no requirement of further
The word allowed was not allowed. It was allowed us to
Make submission.
Make submissions.
All
as
right.
an intervener, but there
তাহলে
was
লিখে নিতে 26 এর order যে
All the intervening.
the applicants
well, Lord, you may kindly pause. My mistake in paragraph.
Allowed.
So I allow all the intervening applications, can number 1, 2, 3.
that is the reason it is not reflected.
Yes, but today there is a better
All
wording,
right,
right
ঠিক আছে।
correspondence.
আজকে শুধু অর্ডারটা লিখে নিন যে the applicants will be at liberty, ওই যেখানে বললাম না এফিডেভিট দেওয়ার জন্য ওই প্যারাগ্রাফটা দিয়ে দিন। That is the reason it has not been reflected. আচ্ছা 27 কিন্তু সেম অর্ডার as 18 হলো। 28 টা হচ্ছে fix it later on. List the matter for further consideration on 8th of December.
My lord, item 28.
28.
Next item 29.
29.
Well, 29 to 33 has been time has been sought for by the petitioners in the morning, Millard.
29 to 33, 37 and
33,
30.
37 and 38.
কবে আসবে? When is it fixed?
10th, Millard.
আচ্ছা ঠিক আছে। Has order been recorded?
আর দিল তো।
ঠিক আছে, লিস্টের নিচে লিখে দেবে 10 তারিখ। অর্ডার হয়েছে?
শামীমই তো ছিল তো।
ঠিক আছে, বুঝে গেল। দেন
শামীম ছিল তো?
এইটা আমার কাছে নেই।
আচ্ছা 34, call 34.
একটা লেডি এসে বলেছিল,
জুনিয়র এসেছিল।
হ্যাঁ লেডি একটা মহিলা এসে
Similar to item number 8, applications are there to be allowed.
এগুলোর নাম কি?
চৈতালি মুখার্জি।
Opposition হচ্ছে
34 না, তারপরে
18 মতনই হবে। 35.
35 is mine, my lord. This matter relating to, my lord, group C and D. They published a rule, my lord, 2025 regarding non-teaching staff, my lord. I have threefold prayer.
That is different. I'll not tag up with this.
That is in that rule, 5 marks is allocated as a.
I don't have this.
Yes.
Number 2 is
But
that.
the rule is different. This is for the
And the second thing is that, my lord, till date, they
No, but I don't have it.
regarding group C and group D, who are the tainted one,
all right.
and who are the tainted one in respect to the expiry of the pen. Then who are the tainted one in respect.
And date of the applications is over. Hard. All right.
December is the last date.
আচ্ছা ঠিক আছে, তাহলে এটা item 35. You mentioned this matter in the morning. Similar order has been passed.
That is regarding, my lord, group CD, but
Group
that
CD
is that person not get the OMR.
OMR, আচ্ছা
So that is the
এটাকে একটা কাজ করুন, 35 we'll keep it on the 2nd,
second.
2 তারিখে।
I need this matter.
List on 2nd. 35 commission, please take note.
My lord.
It is 2nd.
My lord, pardon me. Second, there is a critic order for that.
All right, so third,
Last date.
is the last date, you say. Monday, if after all this is over, তাহলে no order to be recorded, let it remain in the list. Same position, let it remain. আচ্ছা 36.
36, I am for the petitioner. This the issue is not I supporting the 10 marks, but they are not following the circular. The earlier occasion, Your Lordship passed the order because they are giving the double benefit. The 9-10 teachers are getting the experience marks for 11-12 schools. That is a challenge. Because there is a notification, there is the
Let it
one.
remain in the list
Yes.
as it is.
There is the 6 scan application.
Yeah, all the applications allowed. লিখতেন 36 নম্বরটা লিখুন তো। The
One application 6 is they are supporting. But other
however, all applications are allowed.
Same steno আছে।
আগে যেরকম ভাবে allow করলাম সবগুলোকে, they may be adversely affected বলে বললাম applicationটা।
ডাউনলোড করে পাঠিয়ে দেবো।
Yes, cascading effect, সেই জন্য এটা 36 এর applications are allowed. Opposition file করবে।
But the steno is same.
List
26,
list on second.
26, 27 আমি ওকে শেখাতে পারবো না এখন তাই এটা সম্ভব না।
Opposition reply file. 37.
কেউ নাম বললাম
37. ও 37 38 হয়ে গেছে। 39.
39 part-time teacher claiming 10 marks for benefit of.
Then it will go for the
adjourn to 10th December.
10th of December.
8 perhaps
ও আচ্ছা 8 তারিখ। আমি 44 পর্যন্ত ডাকবো।
35 group 3 and
40.
40 EWS
Monday it will appear, কিছু order লিখতে হবে না। 41.
you're giving the names now.
I am my lord, a candidate who had participated in the 2016 election process and have lost the job because of the my lord judgment. I am challenging the rule, the part whereof, if lordship kindly takes up my lord, the brief my lord once, I'll be 2 minutes, I'll finish.
Tell us what is there.
First point is that it has been in the course of my lord submission, someone has submitted that there was no my lord specific place.
41.
There was no specific my lord column in the application form from where it will be appearing as to what is the count of my lord seniority in respect. There was an application, specific application. Lordship has also fixed one matter of mine on Monday where we were not able to provide the teacher's code. So therefore, there was specifically, there is a provision, there was a provision in the my lord, website where the forms were being filled up for counting the teacher's experience. Number eight, in this matter, my lord, I have challenged, my lord, the part where my lord, D is prior teaching experience 10 marks. Lordship has been shown that particular provision. Under that, there is a provision at the secondary level, a government or government aided or government sponsored school calculated on the basis of 2 marks of each year of service in substantive post within bracket as permanent or contractual basis. I am challenging this contractual basis because my lord, teachers.
Well, this is under challenge already.
Contractual.
Yes, part-time, contractual, central government,
Unaided,
ungovernment, all.
I kindly request one order that this is my point of challenge, my lord. I'll be relying upon one judgment to substantiate that the contractual persons who have been my lord taken in through the back door are my lord, their integrity has been questioned, and say Supreme Court has said that persons who have come through backdoor because of the nepotism in appointment of contractual teachers, because there is no check and balance in the rule which says that while taking up the candidature of a contractual person, you have to go through certain measures as to, you have to first see as to whether he is an illegal appointee or an irregular appointee. Illegal appointees, persons who have not.
All right, this will be taken up.
This point will kindly be taken.
It is there in the list. I'm not recording an order. Let it remain because the arguments are going on. As and when the matters will be taken up, it will be heard. I'm not recording anything. 42. Yes.
Similar to 18 rules has been challenged. Additionally, already has been made that private institution who are serving.
Private. Let it remain, no order recorded. 43.
43, my lord, 10 marks for Kendriya Vidyalaya teachers, my lord, I have covered by your lordship.
Very well. Let it remain. 44.
Unaided school teacher.
Let it remain. No further. এবার যেগুলো পাস ওভার হয়ে গেছে একটা
Malar kindly keep this matter.
I'll take up. Commission is here. I'll take up.
The order is not uploaded.
I know the order is not uploaded. I have checked up. Yes, yes. Same order will follow because I did
just
not
indicate
change.
two things, then Milords will decide.
No, I'll take up because I need to see. Just wait.
এ বলেছে যে ও
on the basis of the date of publication of the
এই 111 ভেজো
Very well. It is your submission, and then you can modify your submission. It has gone down.
পারবি একা না দুটো লোক দেবো না
Item 20. Yes, what is it?
111 ভেজো
Next day?
এই দাদা এটা দেখ ও দাদা ও দাদা
270 তো হ্যাঁ 270
এই যে পেজ নাম্বার 39 এটা হচ্ছে ফর্ম এখানে লেখা আছে যে এসসি এসটি ক্রিয়েট এর জন্য 2 টাকা দিতে হবে এবার আমরা যখন প্রাইম অফিসি হয়েছিল যখন প্রাইম অফিসি হয়েছিল সেই সময় আমরা এটা ফিল আপ করতে বলি আমরা বলি যে যেরকম যা কিছু করো আমরা পরে নোটিশ দেবো তারপরে আমরা একটা নোটিশ দিয়েছি
আইটেম 20 আমাদের নয়
বদমাইশি করিস না তারপরে আমরা একটা নোটিশ দিয়েছি নোটিশ দিয়ে বলেছি যে তোমাদের যা আছে এডিট অপশন করে তোমাকে ফিল আপ করে ফেলতে হবে এই তারিখের মধ্যে আর লাস্ট লাইনটা পড়ো
The one minute. Teacher died in 20. Did he submit the option? He didn't. The widow wants to submit. This is 1990 covered.
BPO
রিভিউ হয়তো বলছে
There are better orders which mentions about the 1990. Where is that?
But she slept over her right.
Even thereafter, considering Mukti Moi, I have passed orders specifically recording that the teacher exercised option in 1990.
You were right. Multiple SC candidates, the category as per addendum, and accordingly, we are categorized. কি করতে হতো কি করার দায়িত্ব ছিল ওদের
I have followed in those matters also. You could not find.
ও শুধু 200 টাকা দিয়ে বসে আছে 200 টাকা দিয়ে
What you got? I am aware, but then
কোন কিছু হয়ে যাবে আমার রিজার্ভেশনের পুরো শিডিউলটা কি সম্ভব নাকি
ছিল ওখানে কিন্তু ফিল আপ করেছে এই ম্যাটারে করেনি
no, no,
কালকে যেটা যেটা ডিরেকশন দিলো যে অর্ডারের বেসিস আমরা এটা করতে যাচ্ছি ওই ম্যাটারে অ্যাপ্লিকেশন কমেন্ট টু ইনস্ট্রুমেন্ট দ্যাট প্রিভিয়াসলি দ্যাটস ওয়াই ডিরেকশন ওয়াজ পাস
জিজ্ঞেস করতে
আমি ছিলাম কালকে আমি কালকে রাহুলকে লিখেও পাঠিয়েছি
ওর মার্কস কি হায়ার ওর মার্কস কি হায়ার দ্যান লাস্ট এসসি কথাটা লিখেছে
আমাদের না মুক্তিময়ী পালের অর্ডার রিলাই করে অর্ডার আছে ঠিক আছে আমি এটা করে লিখে রাখলাম উনি এটা দিয়েছেন দেখে নিতে হবে ভিডিও হ্যাজ কাম খুঁজে দেখতে হবে আমি এটা ওখানে রেখে দিলাম অলরাইট ডিসপোজড
কত নম্বর আই
21 yes who is appearing private respondent
বলার নেই তো
no objection type of thing right
Now, Lordship, I received this affidavit.
you are the sister
Yes, ma'am.
you do not have any objection if the
No, ma'am.
pension is given to
I'm reading
your
my-
all right
I've also-
only 2 sisters 2 daughters
Yes.
There are others also?
Others also.
They are younger.
Young.
Oh, they are married.
Married and some.
All right.
Your Lordship, the kindly come the impugn order. My prayer for.
Who's for the state?
Let's say I have served notice. Last notice has also appeared.
Shayan Ganguly is there? Bring him. In his absence, I won't take. Not today.
Lordship, Monday, Lordship, kindly at least some preference, Lordship, because.
So what? Monthly list means the other list will not be taken up. It is a list only. Call 22.
22.
Yes.
22. The husband died prior to publication of the.
দাদা এখানে রাখবো এর আইটেম নাম্বার 111 না
111 এই তো মোটে 111 তো মোটে 111
এই তুমি দিয়ে দিই এটাই দিটা হ্যাঁ
এখানে ভিডিও করা আছে, এটা স্পাউস করবেন অফ দ্য ডিসিজড টিচার। Disposed.
Lord, I am appearing for this.
Yes. Yes.
The matter is that the similar matter that was yesterday was argued by Ms. Lana Senior, Mr. Pradeep Bhatt, and the judgment, the WPA 26973 2025. Your Lordship, I just wanted to file the affidavit of service. As well as Your Lordship, the supplementary affidavit.
But only difference is
111.
supplementary number key.
Yes.
Schedule
What
class
is
certificate.
supplementary for?
Give him a copy, commissioner copy.
Oh, you annex the notifications.
Yes, the notifications and Your Lordship, the certificate. Certificate certificate. Your
But
Lordship,
the difficulty,
Read petition, you did not annex your certificate.
no.
missed out at Your Lordship, that's why.
Out.
Lord, the difference is of the last matter, Milord. I am led by. But the difference is, Milord,
I am a reserved category. I filed as an online form requisite fee paid by 200 rupees and I'm entitled as a SC candidate. That was proved by my certificate, Your Lordship. And the thing is that I also cleared the cutoff. That is SC got 54, I got 59, Your Lordship. And the verification date is on Monday. And if it is not decided by today, Your Lordship,
Milord, in the last on
Difference
different
between
matter,
the other one.
difference between other matters, there they had filled up the form. Here they did not. They sat over their rights.
I filled the form. Definitely I filled the form.
Check up.
No, on instructions I am saying.
There.
Rectification form in terms of page
Your
58.
Lordship, that
There is no
Not the
rectification.
rectification.
No, even when we
Initial.
Milord, there was no space. Initial, Milord, what we had done was, because the OBC matter was pending, there was a category where the SC, ST and PH category were supposed to pay 200. That is been indicated. Milord will kindly take up the form, Milord.
39, page 39.
Page 39.
The thing is that here I'm also, if the certificate was delivered by the competent authority, Your Lordship, I am a scheduled caste candidate just because I'm.
Listen, did you disclose your scheduled caste status in your application form?
No.
I did.
Show where it is.
Your Lordship, when I am
39 to
filed.
59.
Page 39, see.
Your Lordship,
No.
each and everyone's form, that is, requisite form is 200, that for SC, ST, TH. That means I am entitled as a reserved
No.
candidate.
No.
Definitely it is.
No.
For a general, that was in 500, Your Lordship. And I am SC candidate, that was proved by certificate. Of course, I am, the competent authority is giving me the authority to, I am.
Nobody is challenging your status.
Form, when I'm filling the form in online, I filled up each and everything details and all documents was there. And after that, they give me an admit card for that. Lordship, I'm competent and that's why I just wanted to show the rule, Your Lordship.
2-1R reserved category. That has been placed yesterday. That was placed.
But everything my friend is submitting, Milord, is
Same.
right. But
Only.
they did not fill up the form.
All right. Yesterday's matter, it was filled up.
It was filled up.
was not, your lordship.
How will you know? He knows it better because he has briefs of everybody.
Form on a rectification form.
Yeah, the rectification.
See that 39 page, 39.
Form by form, he means rectification form was not filled up. And in yesterday's matter,
No, yesterday matters rectification form was not filled up.
But in page 39, it shows that SC, ST, PH. It does not say that the candidate is SC or ST or PH. It only says that the ST, SC, PH has to pay 200, which I admit that she might, the client, the petitioner might be SC. I am not denying that. The point is, when there was given a chance to rectify and to fill it up, they did not do it.
No rectification, same order will
this
go.
has to be read with page 58. Kindly read page 58. Kindly read page 58.
See, your lordship, the previous, yesterday.
Yes, this notification was shown.
Grateful, your lordship.
This was shown. Same order. কালকে একটা order দিয়েছি।
We will record our submission and then Miller will pass.
Item number 4. জেনে নেবেন। Same order যাবে। In the instant question as to whether the petitioner who claims to be a scheduled caste category candidate and participated in the recruitment process by depositing rupees 200 meant for the reserved category candidates in respect of SC/ST and PH can be treated as general category candidate if the candidate did not update or edit the caste relying on the addendum notices issued by the commission. The aforesaid issue has been decided by the court on গতকালের date in WPA নাম্বারটা দেবেন, পার্টির নাম দেবেন। As the issue has been decided by the court, accordingly, the same observation and direction will apply in case of the petitioner stuff. The date for credential verification of the petitioner is scheduled on 1st December 2025 stuff. The petitioner shall be treated as scheduled caste category candidate. ঠিক আছে? আর প্রথমেই একটা affidavit of service and the supplementary affidavit filed in court is taken on record. Copy of the supplementary has been handed over to the learned advocate representing the respondents in court today. Writ petition stands disposed.
Not only one sentence if it goes in that for 200 rupees, there are 3 categories which can be availed. That sentence if it goes, nothing more I am.
You treat him or her in any of the categories, not in general. This is the thing.
That cannot be, if he is a C.
Tell me one thing. You have fixed 500 for general.
Yes.
And 200.
200 for SC, ST and PH.
Right.
He did not take the botheration to fill up the form.
Wait. Any candidate who pays 200.
Yes. Can be PH also.
Cannot be general.
No, yes, Milord. Milord, my question to myself is, can we treat him as a PH category candidate?
All right, you treat him PH. Can you treat him as general? Your notification will be treated as general.
But by only
can you do that?
By only paying 200 rupees and not specifying that for what reason he is paying, then how can it be accepted?
I understand your what you are saying.
Because everything has to be changed because of he was sleeping.
Your notice mentions they will be treated as general. Somebody who will pay 200 will get the benefit of rupees 500.
Milord, when somebody is a Rip Van Winkle, Milord, what can be done? He's paying 200 and going off to sleep. That is the difficulty. The entire administrative difficulty happens that way.
Yesterday, your lordship had decided all this.
How are you doing? What is the rationale?
Milord, the question is how they are doing it also. Milord, they should also be, Milord, vigilant, and they should also be alive to the facts, that there may be.
Assuming this is not a case. Assuming this case.
Whatever is falling from your lordship is a general proposition.
General, yes.
Let us assume, a selection initiated by a process. That selection has various stages. I, a candidate who is participating in a selection where lakhs are participating and giving applications, am I not supposed to at least pay a visit to the website as to whether some new development is there or not? I put this question to myself.
Reject applications, do not pay prescribed application fee.
Yes, true.
Supplementary list.
only one
আমাদের নেই চলো
এটা কি affidavit দিয়েছে?
বড়রা সেকেন্ডারি যাবে প্রাইমারি
One is the verification date.
It has been mentioned verification date.
only one intelligence matter. Item number 93 is identical on this point, my lord. Your lordship just decided.
When is the date of verification?
only
Date
thing
of
my lord,
verification is one. First of yes.
93 you
and see-
mentioned in the morning.
No, only one. My lord,
withdraw করুন।
I was waiting this this
Then
matter
keep
maybe.
waiting.
But only
My
one.
lord, item
Can it be-
111 my lord,
can it be
urgent
taken up on
copy,
Monday?
server copy my lord,
My lord, can it be taken up on Monday?
because it is Friday my lord.
See what is the time?
Yes.
You all submit urgent and I sit here till 8 and 9. Everybody goes home. It's only this poor fellow sitting over here.
Can it be taken up?
The reason we call your ladyship your
Monday, your lordship, can you take it up Monday?
My
Or can it
that's
be
without
upgraded?
tea.
93.
Year filed up. Mr. Nag, don't go. Item 93. Check up your file, please. The supplementary item 1.
I'm for the petitioner.
Led by Mr. Sannal.
I'm led by Advocate Shobhojai Chatterjee. On last occasion when the matter was-
Howrah.
Is it the determination of Justice Patnaik?
Yes, Your Lordship. Yes, I have
Primary.
served notice.
Patnaik, Justice Patnaik's determination, please come. Please. The matter has been, the matter relates
Lordship,
to
it is for
primary
extension of
education.
interim order. Your Lordship, it is for extension of interim order. The interim order expires on 30th.
Oh, this is for extension.
Yes, Your Lordship.
Acha. Ki bollam? The matter relates to primary education. Sir? Honorable bench taking up primary education matters being unavailable, the matter has been assigned before this bench. Stop. The petitioner prays for extension of interim order, which is due to expire today. Stop. Paragraph. For ends of justice, the interim order that is subsisting is extended till
My lord, a limited period, 1 week, my lord. In the meantime, my lord, he will get the my lord, the regular bench, my lord. We are hardly contesting this matter, my lord.
not contesting.
Yes, contesting, my lord.
Acha. In that case, সোমবার থেকে তো bench আছে 12th December or until further order, whichever is earlier.
Your Lordship, interim order is till 30th of November.
Yes. আচ্ছা till today বলেছিলাম সেটা হবে 30th November. Subsisting, এটা হচ্ছে extended till 12th. List the matter before the regular bench on 3rd of December.
Grateful,
Subject to the convenience of the court.
grateful.
So I am for the petitioner.
Yes.
This is, my lord, for participation in new recruitment process initiated by the West Bengal Board of Primary Education, my lord. My lord, petitioners are the pursuing candidates of 2023, 2020.
Not tell me the merits. I am not going to
My lord,
hear.
let it be placed before the bench, my lord.
Honorable Justice Patnaik.
Yes, Honorable Justice Patnaik, my lord, this has been filed with leave, but it was
আচ্ছা,
not
ঠিক
heard.
আছে। Please come. ওই প্রথমের প্যারাগ্রাফটা থাকবে।
দশটা শুধু জল খায়, চা খায় না।
ঠিক আছে?
জিজ্ঞেস করে না, এখনই করুন।
Second paragraph লিখুন।
আমরা কিন্তু চা না
It has been
খেলে-
submitted that
চা না খেলে
there is extreme urgency in the matter.
তো যাবো আমরা।
Stop. Prayer has been made for hearing the same on urgent basis. Stop. Paragraph. Due to paucity of court's time, comma, hearing of this matter cannot be taken up today. Stop. Let the matter appear in the list before the regular bench on 1st December 2025, fairly at the top, subject to the convenience of the court. Three, three,
Three malad similar to item number 2 malad.
same order can be
Yes.
passed. Same order passed.
Not-
4,
Same as two.
same as 2.
5 is mine.
5, same order. 6, same order. 7, same order. Very well. আচ্ছা
Malad, may I
93টা
indulge one
মেনশন
thing?
করলো।
Malad, may I indulge one
All the matter, my lord, we are appearing.
Item number 35, that is regarding malad group CD rule challenge. The last date of online application is 3rd. Malad.
Yes.
So it will be kind enough to give some preference of the item number 35, that is for us.
Preference see other matters is being hard.
That one, otherwise, malad, again after form fill up, they will proceed it.
আচ্ছা,
There is the
do
same
one thing.
travel. Malad,
Do one thing, 35টাকে এই মামলাগুলোর উপরে নিয়ে চলে আসো।
malad, otherwise, malad, same travel will happen. Malad.
Slip. Somebody mentioned 93.
Identical to my lord, but your lordship has just passed order.
No, you are taking.
No, yes. Show me your application form.
The application form is at page 41.
41. Same thing, Mr. Nag.
Well, I'm just checking.
All slash.
Yes, that is for everybody. All those who filled up, who took the pain of filling up their responsibilities of SC, ST, their form also says the same thing.
That means y'all did not categorize.
Well, at that stage, at the beginning stage, we kept it that way because we gave a subsequent notifications, gave them the option to fill it up. They were
But then
sitting on
that
their
was in respect of the OBC matter.
for
How
OBC
are they-
matter, for OBC matter for everybody, this was done except for EWS.
That is my case also.
Why is it so? What is the rationale?
Milord, there was Milord, that particular thing was there was no what do I say, inequality among the candidates.
Item 20, item 93. Same as, which was the other matter? 111. 111 এক্ষুনি নিয়ে গেল বোধহয়, নাকি আপনি নিলেন? ওই ইয়ে নিয়েছে, পলাশ বাবু নিয়েছে, ওইটা নিয়ে নিন। আচ্ছা ইয়ে অনিমেষ